Gutmann and London and South East Railway Limited and First MTR Southwestern Trains and another.
Yes.
May it please the court, I appear on behalf of one of the appellants, London South East Railways, with my learned juniors, Mr Armitage and Miss Blackwood.
Yes.
My learned friend, do you want me to do that?
I think we've got the cast list actually.
Very Mr Moser on my right and
Yeah.
Mr Jowl on my left.
Familiar with.
May it please the court.
Before you start, can I just raise two things? First of all, I think formally the court should disclose that each of us either has been or either is now or has been in the past the owner of a travel card, whether an Oyster card or whatever. And I think formally we, as happened, I think certainly happened in Merricks in the Competition Appeal Tribunal. I think indeed in the Supreme Court, I was told, they had to undertake to forego any claim they might have to in the litigation, which I think we will willingly do. And the second thing was this, that obviously to an extent my lord and I touched on some of the issues in the Le Patrel case, but they were not directly in point. We wouldn't want anybody to feel that they were constrained by what we said in that case into not arguing what they would otherwise want to argue. So don't feel constrained, and please do argue whatever you would have argued, and we will keep open minds on the subject.
My lord.
No, thank you very much.
Thank you. Unless there are any housekeeping issues, I would propose to just introduce the two main submissions that I wish to make and then make them, but identify that there are 4 sets of submissions that I have to make, and with your lordship's permission, I will make those this afternoon, and then Mr Jowl for the other sets of appellants will be on his feet tomorrow morning up until lunchtime or thereabouts, and then it will be Mr Moser, and then there'll be a shortish reply. Depending upon the level of engagement, we may well finish by Wednesday lunchtime, but of course we do have the option of Wednesday afternoon should there be.
Yes, we'll try and not to interrupt too much so we can finish by Wednesday lunchtime.
I'm very grateful. So what I have, the first 2 sets of submissions are what I contend to be errors of law in the judgment of the tribunal concerning certification, and the second of those sets of submissions will be shared with Mr Jowl. He's going to develop them in detail. And I will introduce both of those 2 sets in just a moment in overview so that the court has a clear roadmap for where we're going. The third set of submissions I'm going to make much later and much more briefly concern what I contend to be flaws in the methodology that has been advanced by Mr Holt, who's the expert for my learned friend's client, the PCR, that's to say the proposed class representative. If I use that terminology PCR, that's what I mean, Mr Gutmann. Yeah. And its flaws in what's become known as the overlap. That is to say, people who both have a travel card and take a relevant in-scope journey. So that's going to be the third thing, and that'll come much later on this afternoon. And then the fourth set of submissions are in the case of LSER, my client, South East Railways. We, as you know, made a strikeout application and it was denied, and I appeal against the strikeout. That concerns third-party retailers and advance fares. So again, that'll come right at the end, and that'll be a lot shorter. The first 2 sets of submissions, the ones about whether there should be aggregate liability under section 47C2 at all, and if there is, then how does the methodology have to coincide with that? I contend that there are alternatives in this case, in this sense. My respectful submission is that if I were to win on either of these first 2 larger sets of submissions, then this appeal ought to succeed. And I'll introduce them in a minute, but before doing that, I'd just like to respectfully remind the court that what Lord Briggs said in Merricks in the Supreme Court, and this is at paragraph 64, is, and I quote, "Too much compartmentalisation may obscure the true task," unquote. No doubt you're familiar with that. And what I say before I introduce the 2 sets of submissions and then make them is that that's very apt here. My learned friend says in his skeleton that the key issue, the central issue, the only issue is really about commonality. And then he proceeds to analyse it through that lens. But we reject that. We say, my basic submission is that this set of facts for these appeals is not one that should have been granted certification so as to proceed forward. And now you can look at that through the lens of commonality in part, but one also has to bear in mind that under Rule 79(2)(a), that refers to the, quote, fair and efficient resolution of the common issues, and we say that this case would not fairly proceed in the manner in which it's put forward. You can think about it as well, whether it should be, there's not an appropriate methodology for the purposes of this case, on this set of facts. You can think about it further as being, this case is not one in which it's appropriate to have an aggregate damages methodology, or at least the one that's put forward. My point is really that it's my first two sets of submissions are a combination of all of these points. They are not simply about commonality, and too much compartmentalization in that way has been eschewed by the Supreme Court. So that then takes me to a thumbline sketch of the first topic, what we call in our skeleton the first alternative. And it is in outline the following, that the law of the land does not include the ability in a collective action to establish aggregate liability as opposed to aggregate quantum. Instead, there has to be individual liability in each case that is combined together. Each case has to be theoretically capable of being pursued as its own Section 47A claim, in the sense that it each has to amount to its own cause of action. That is very much the fundamental first point that I make. It is a truly interesting and important issue, and it has given rise, in my respectful submission, to some degree of confusion in the, but not just the judgment against which I appeal, but other CPO judgments that have come since then. And it's starting to recur. And what we say, again, this is just the outline to set the scene, is that whilst it is permissible under Section 47C, subsection 2, to have aggregate damages, and they can be computed in a top-down manner without assessing the individual amounts of loss, that was a significant and deliberate change to the substantive law of the land that was made by Parliament, but Parliament did not go so far as to introduce two significant changes to the substantive law of the land, the second being aggregate liability. If it had intended to make that second change, it would have had to do so expressly and explicitly, and on no view of the world in my submission can it be said that that happened in Section 47C2. So that's an outline of the first one, and I'll obviously develop that fully in a moment. But just so that you know how they fit together, an outline of the second set of submissions is what we call the second alternative in our skeleton argument. It is this, that if contrary to this first argument that I make, it is the law of the land that you can have liability in an aggregate in collective proceedings, then nevertheless there must still be a way of ensuring that that liability that is established in that manner is not an over liability, leading to overcompensation. And that's because it definitely is the law of the land that a defendant cannot be made to overcompensate, i.e. to pay damages for situations in which it is not liable. Indeed, nobody suggests otherwise. But what that means in practical terms is this, in my submission. At the certification stage of a collective action, if it can be seen that there's a realistic prospect of the aggregate damages methodology that is being put forward will result in over-inclusivity, that is to say, it will include situations for which there's no liability, and hence will result in an overcompensatory aggregate award, then that case cannot be certified. Now, that doesn't mean the end of all aggregate top-down cases. Far from it. It means that there will be some methodologies that are put forward. Notably, they're likely to be top-down ones that take aggregated data from the top and then go downwards. Some of those methodologies can still survive if, and this is the big if somehow on the given fact pattern for that case, they permit of a fair and just way of removing the non-liability situations in the aggregate. And my basic point is this. Not all fact patterns allow that. So some of those cases can't be certified. And further, the PCR must show at certification that there is, in fact, a fair and just way of removing those non-liability situations in aggregate. And that fair and just method has to be one that is plausible and credible and grounded in the facts of the case and for which there's evidence of the availability of data. And I say that, you'll no doubt recognise each of those 4 points because they are from paragraph 118 of Process versus Microsoft. And what I say is that it's not sufficient for a PCR to attend at a certification hearing and just say, oh, don't worry, trust me, I've got an expert, I'll be able to do that. That doesn't hit the test. And it's no good for the PCR to say, I speculate that there might be a way of removing these over-liability situations. That's not good enough either. That is not a proper scrutiny of the court. And the problem in this case is that the PCR hasn't advanced, in my submission, an aggregate methodology, bearing in mind that his is an opt-out, top-down methodology that excludes the realistic prospect of non-liability situations. And instead he does essentially say, don't worry, I'm an expert, I'll be able to do it at some point somehow. So those are the two sets of submissions. And that's how I hope they fit together. So turning then in more detail to the first topic. So this is the one, no aggregate liability, only aggregate assessment of quantum. My first point is this, that there's no suggestion that the collective or class action regime in Canada does not work perfectly well. Indeed, it was chosen because it was seen as the best option. If you were, we don't need to, but in the tribunal's judgment in this case of paragraph 11, the tribunal states, quote, Parliament regarded the Canadian regime as the best model, unquote. And that, of course, is echo, had been said, that's essentially an echo of what is said in the Supreme Court in Merricks. Yet this is common ground. Canada emphatically does not permit aggregate liability, though it does permit aggregate damages. And I just want to show you, if I may, the point in process that makes good that submission. If I could invite you please to turn up Authorities Bundle number 4 at tab 26. That's the Microsoft process case in the Canadian Supreme Court. And this is not for the famous paragraph 118, we'll come back to that, but this is instead for the other finding in that, or one of the other findings in that case. And if you turn up the report, please, at paragraph 131, which is to be found on bundle page 1012. You'll see how emphatic the finding is in Canada. So it's page 1012, left-hand column at the bottom, paragraph 131. And what the learned Chief Justice says is, with respect, I do not agree with this reasoning. The aggregate damages provisions of the CPA, that's the Collective Proceedings Act in this case in BC, relate to remedy and are procedural. They cannot be used to establish liability. And taking it further down is a reference to the specific provision, and then he says, as I read it, this means that an antecedent finding of liability is required before resorting to the aggregate damages. And the last sentence, I do not see how a statutory provision designed to award damages on an aggregate basis can be said to be used to establish any aspect of liability. And then similar comments made in 132, the top of the next page, in the English column. I mean, one could trace that down and see that it finishes with a reference to Ontario, where likewise the Class Proceedings Act is procedural and cannot be used in proving liability. And then interestingly, and I'm going to come back to this, there's a reference in 133 to Hansard, albeit British Columbia parliamentary Hansard. And in particular, the Attorney General was to describe the regime, picking up about 6 lines down. In simple terms, all we're doing here is finding a way to enable the access that individuals have to the court to be an access that individuals combining together can have to the court. The CPA was not intended to allow a group to prove a claim that no individual could. Rather, an important objective is to allow individuals who have provable individual claims to band together to make it feasible to pursue their claims. And we say, exactly, that is a workable regime in Canada, very explicitly doesn't allow aggregate liability, and that is the model that is most closely the English model and the one that we are said to have based ourselves on. Now, of course, I don't say that we're identical in every respect, but what I do say, and I'll come on to this with reference to some more case law in a moment, is that it cannot be said that it is necessary in this country for us to have aggregate liability as well as aggregate damages, because our closest model definitely doesn't have that. It couldn't be clearer.
Can I just ask you how it would work in a case like Merricks, when you've got a class of about 45 plus million individuals? How does the tribunal then deal with liability on your analysis?
Let me give you a short answer straight away, and I'll obviously be coming back in more detail to Merricks. The answer in Merricks is a peculiar fact pattern, though it may be replicated in plenty of other overcharge cases. Right? All that one has to do in Merricks to have a prima facie case of liability is purchase an overpriced good. The class was defined in Merricks to be all those people who purchased overpriced goods. And so therefore, the question of individualised liability doesn't arise in that case in the same way that it arises in this case. So to put that point another way, if you're in the class in Merricks, defined as people who bought an overpriced good, then there's a prima facie case of liability. There are no difficult counterfactual questions in Merricks about, well, if in the counterfactual world the facts had been different, how would have I interacted with the counterfactual world? And if I interacted in a certain way, that would have given rise to liability, but if I interacted in another way, it wouldn't have given rise to liability. In those sorts of cases, which is this appeal, you can't say that it's a simple yes-no dichotomy. Did I buy, in which case there's liability, or at least prima facie liability at an interlocutory stage, or did I not buy, in which case there's no liability? That's the big difference. And my submission in due course...
cover each and every one of the 46 million members of the class?
It does, my lord. And as I shall develop in a moment, this point was not taken by MasterCard. This point about aggregate liability being a problem was not taken. And the reason it wasn't taken was because in Merricks, it's very easy to see, with respect... sorry, my lord, would it be possible to just draw the blinds down behind you? Because I'm getting a great big sunlight glint off that white... It's like a bad cricket.
Need your screen to just.
I need my. Would it be possible, or at least? Oh, brilliant! Thank you so much. Yeah, sorry. I've now got sort of sunlight flashing across my retinas. Is that better? Much better. Thank you so much.
Okay, stop now. So you were telling us that the point wasn't taken in MasterCard?
Yes, the point wasn't taken in MasterCard, and that was for this reason, as well as the one I've just given about it being a straightforward: did you buy? Did you not buy? The reason was that the class, the way in which that claim was constructed was that anybody in the class, MasterCard accepted that anybody in the class would at some point in the claim period, somewhere in the country, at some moment in time, have bought at least one good or service from a retailer that accepted MasterCards. Bearing in mind that at the beginning of the claim period, there was something like 550,000 MasterCard accepting retailers in the country, and by the end it was something like 800,000 or 1 million, or I can't remember. But that was absolutely critical. They accepted all the way along that if you bought and you were in the class, then that was prima facie liability. Whereas in this case, as you know, we don't accept that. We don't accept that in every case in which there was a potentially in-scope journey, even one for which there was a person had a relevant valid travel card on their person, necessarily in the counterfactual world, they would have suffered a loss. Mr. Zhao is going to develop those detail points on this case, but you can see the conceptual difference between the two. And my point, my lord, is this, that this is by no means the end of this regime, if I'm right on these submissions, because there will be many, many cases like Merricks, many overcharge cases. Take Le Paterel, with which at least two members of the court are very, very familiar. That again is, if you're in the class, you were overcharged. That's the end of the story. You know, you were overcharged by BT on the theory of that case. And there are no difficult questions about the counterfactual. No, there are no individualized questions about liability. Take an excessive pricing case. Again, if you were, which is not, I accept, a million miles away from BT Le Paterel, but if you're in the class, you were overcharged. You don't have to worry about any difficult liability questions or individual bespoke interactions.
In Le Paterel, there were two classes. There was the consumer class, there was the business class. The position vis-a-vis the business class was less clear and would have given rise to a dispute at trial as to the scope and extent of any loss suffered by that second, much smaller class of customer.
I'm happy to look at that again. I was talking principally about the main class, but
yeah, I understand that one.
Yeah, and I will look at that point again, and I'll happy to come back to you.
And again, in the letter about Le Paterel, we were not addressing this issue vis-a-vis anything other than knocked-out guarantee. And that's one of the reasons we recognise that we need to look at these principles in the context in which they arise.
Yes, that's right. But those are my answers to your question. That all I am talking about, especially in the next part of my submissions, when we look at how you have to have part of methodology that will take out from a top-down method those bits that are not liability that would be overcompensatory is I'm talking about aggregate, top-down, opt-out cases. And what I say is that there is a certain subcategory of that double subcategory where it might not be possible and there should be denied certification. And those factual cases are the ones where, like my case, there are lots of individualised bespoke questions going to liability. But in Merricks, which was an aggregate top-down case, there weren't those individualised bespoke questions going to liability. Now, it is true, I'm getting slightly ahead of myself, but I can see the interest of the court in the point, and we're going to hear this from Mr Moser, because he's determined to submit to the court that, in fact, this question was live in Merricks, but it wasn't. I appeared in Merricks, and my solicitors appeared on the other side in Merricks, and this point about aggregate liability did not appear. It wasn't a live question. The closest that it came was that MasterCard made submissions to the effect that there would be some people who had very differentiated losses. And that, with respect, is obvious. There would be some people who spent £1 million a year because they're extremely rich in lots of different retail, and some student who's there for 1 year who spent £10 and had very little losses. And in the course of that submission, it was made as an example that there might even be some people who didn't have any loss in a given sector or in a given year or in a given geographic region. But it wasn't a case in which it was submitted by MasterCard that there was a problem about inclusion in the class of people who had no claim at all. And it wasn't a submission by MasterCard in the case that the problem arose because there were differentiated liability positions. Those 2 points simply didn't arise. So going back to where I was, so quite emphatically then, Canada has a regime that works and it doesn't allow aggregate liability. But it does, of course, promote all of the very underlying principles that the court set out in Merricks in the Supreme Court. And with respect, this court largely, if I can put it not unkindly, adopted in BT Le Paterel. So it promotes access to justice in Canada. It favours judicial economy by avoiding duplicative legal and fact-finding. It introduces powerful additional disincentives to infringe the law, etc., etc. All of those apply equally to Canada. They apply to a regime that doesn't allow aggregate liability. And what I say about section 47.2, which I'm going to turn up in just a minute because it's obviously central, is that it could have explicitly permitted or indeed even mentioned aggregate liability, but it refers instead only to the new ability not to have to assess individual damages. And I'm going to turn up in just a moment. But before I do so, you will, of course, be familiar with Professor Mulheron's article that was cited by Lords Sales and Legat in Merricks Supreme Court. And she advocated that the law of the UK should go further, should go beyond aggregate quantum to extend to aggregate liability. That's her thesis. She's an academic in the field. She's entitled to her view and indeed her able advocacy. But the important point is that she recognised as follows. This is at page 1610 of her article. She writes as follows. This is a change in the substantive law. Well, I completely agree. It is a massive change in the substantive law. One might have thought that if there was going to be a massive change in the substantive law about liability, that Parliament would have actually set that out in clear terms. And I'll turn it up in a minute. But you'll recognise that she then does two other things. She argues, first of all, that this second major change in the substantive law that she regards as having been set out in the Act is, quote, implicit, unquote, in the reasoning of the Court of Appeal in Merricks, and I will obviously be coming to that reasoning. And then secondly, she argues that she's right because of, and this is critical, because of the absence of wording in section 47C2. So what she does is she compares it with section 29(1) of the CPA in British Columbia, and she says, oh look, there are some words in BC that aren't here in the UK. It must follow that this second major substantive change to the law is in our wording. So let's have a look at that wording. It's to be found in Authorities Bundle, tab number 5. I beg your pardon, yeah, tab Bundle 5 at tab 41. So Authorities Bundle number 5 at tab 41. I know you'll be very familiar with the Is it in there? Yes, here we go. It's on page 1564. 47C2. The tribunal may make an award of damages in collective proceedings without undertaking an assessment of the amount of the damages recoverable in respect of the claim of each represented person. So I ask rhetorically, where in those words is the second major substantive point, the reference to liability? How can a major change to the law of liability as opposed to quantification be made by a statutory provision that doesn't even mention the word liability? It's not there. There's simply no reference to liability. What it does refer to is the, quote, amount of damages, unquote, and to the, quote, assessment of that issue. It doesn't say anywhere without assessing the liability of each represented person. But in my respectful submission, such a massive second change to the law can't be introduced either implicitly or impliedly, or by inference, or indeed by silence. And it certainly can't coherently be said that any such implication or inference is necessary for the reason that I've already given. A regime works perfectly well without it, indeed the closest regime in Canada.
Can I just ask you a question about the stage at which this arises? Because Section 47C2 could arise at the trial stage as opposed to certification. And I mean, I understand from the tribunal judgment that there's an implicit acceptance that at trial deductions might be made from the global 100% otherwise recoverable to take account of uninjured class members or the category. So you may knock the damages down by 5% or 10% or whatever. But you say it has to be done at certification as opposed to trial. Is that the only difference between you?
No, I'm saying two things. I'm saying that at certification you have to show to the tribunal on that day, by reference to a plausible and credible, fair and reasonable methodology that's grounded in the facts for which there's evidence of the availability of data, that there is a way of removing over liability.
That's your second point.
And that's my second point.
So at this point, I mean, I'm not certain that the tribunal or the other side necessarily disagree with you. They're basically saying it comes to the globalization of the method rather than looking at each of the 4 million plus individuals to make an individualized assessment. And if, for example, at trial you put forward evidence to show that the uninjured class was, say, pick a figure out of the air, 10%, and the tribunal said, all right, we'll err on the side of caution and knock 11% off, where's the harm to you? You're not compensating anybody who shouldn't be compensated.
No, well, there are going to be lots of submissions, including from Mr Jowl, about how, on the facts of this case, there is no methodology because of the bespoke and individualised nature.
That's your point two, isn't it? I'm looking at point one, point of principle.
That is to some extent, but the tribunal did adopt, and where we say the tribunal judgment has gone wrong, did adopt, without any doubt, what Lords, Sales and Legats say about the ability under Section 47C2 to have aggregate liability. We say that that's an error,
right,
and it infuses, if we like, the whole judgment because it proceeds on that premise.
Right. So that's a point of law about the status of the minority judgment in Merricks.
As adopted by the tribunal,
indeed,
judgment that I'm appealing against. Yes.
Yeah.
Yes. Agreed.
So is this really background to saying why the minority is wrong?
Absolutely. I do make that submit precisely.
Okay.
The minority does say, per Professor Mulheron's article, that there's aggregate liability as well as aggregate quantum. I say they're wrong. Okay. And I'm explaining why. Yes.
Okay. Fair enough. Thank you.
Okay. What I'm just about to point out, though, is that there's an important distinction even between the one major change of the substantive law that we do all accept was made in 47C2, namely to allowing quantum to be assessed in the aggregate on the one hand, versus on the other hand, allowing, so the argument goes, aggregate liability. And that is that it's a far more profound change in the law to allow aggregate liability than to allow aggregate quantum. And that's for the very simple reason that by definition, the aggregate quantum, no matter how you do it, bottom up, top down, indeed sideways, is only ever going to be no more than that for which the defendant is liable. Whichever way you do it, you're never going to end up with more than that for which they're liable. But of course, as soon as you start tinkering with, let alone making major substantive changes to the substantive law of liability, it gives rise to the very problem that I contend appears in this case. It can give rise to over liability because there's a danger that you're going to have some people in the class who, when their claims are looked at as individual causes of action, they fail, or there's a realistic prospect that you can see at certification that they will fail. And that's what I'm addressing. It's the certification test. What I say is the law of England is very clear that important rights and common law obligations, of which there couldn't be many more obvious examples than you shouldn't pay for that which you're not liable, can't be overridden implicitly or in general by any ambiguous statutory wording. And just very briefly, if I could take you in bundle number 1 of the authorities to ex parte Pearson, just for the, I know it's a fairly trite proposition, but I want to show you these passages nonetheless, because it is said against me that this point has been decided against me. It's actually been decided. So ex parte Pearson is to be found in bundle number 1 at tab number 2 at page, paragraph 573G, which is to be found on bundle page 55. The facts don't matter. This was a prisoner tariff case. But picking it up in Lord Brown Wilkinson's speech at G, he says, I consider first whether there is any principle of construction which requires the court in certain cases to construe general words contained in the statute as being impliedly limited. In my judgment, there is such a principle. It's well established that Parliament does not legislate in a vacuum. Statutes are drafted on the basis that the ordinary rules and principles of the common law will apply to the express statutory provisions, references to textbooks. As a result, Parliament is presumed not to have intended to change the common law unless it has clearly indicated such intention either expressly, and I'll just pause there, whatever anyone says, plainly section 47C2 doesn't expressly change the law of liability. It doesn't even use the word liability. Or by necessary implication, and that's why I laboured the point necessary earlier on. But it can't be necessary. It could only be implied, but it can't be necessary. So it fails on this test. And then if I could turn for another reason to a similar but different citation, this time in Authorities Bundle 2, the case of Ingenious Media, and this is to be found at tab 10. I want to pick it up at paragraphs 19 to 20. Again, the facts don't matter. It was a taxpayer confidentiality case, and the Revenue decided to make a briefing off the record to some journalists of some private confidential details about a taxpayer. The argument concerned whether you could override this right to confidentiality as a taxpayer, if you like, by the statutory phrase. Yep. So 19, I'm not going to read it all, but I'm going to pick it up between D and E.
Paragraph.
I'm in paragraph 19 on page 398.
Thank you.
And although the whole of paragraphs 19 and 20 are worth reading, I pick it up between D and E, the sentence beginning secondly, that's about 6 lines up from the bottom between D and E. Secondly, and more fundamental, it means that the protection which would otherwise have been provided to the taxpayer by HMRC's duty of confidentiality will have been very significantly eroded by the words of the utmost vagueness. So to construe the words would run counter to the principle of construction known as the principle of legality, after Lord Hospen in Ex parte Sims. And then the citation from Lord Hoffman, fundamental rights cannot be overridden by general or ambiguous words. This is because there's too great a risk. This is the reason I really call up this. This is because there's too great a risk that the full implications of their unqualified meeting may have passed unnoticed in the democratic process. In the absence of express language or necessary implications to the contrary, the court should therefore presume that even the most general words were intended to be subject to the basic rights of the individual. And I pause there, and this is why I mentioned the Hansard point in Process and Microsoft. There is no evidence before the court, there never has been, I'm not aware of any for what little that last point is worth, that the full implications of aggregate liability have ever been noticed in the democratic process in this country. So this argument that's put against me, that section 47C2 does include aggregate liability as well as aggregate quantum, is not supported by any travaux préparatoire, not supported by any Hansard reference. There's no indication that such a massive second additional substantive change to the law of England was debated and recognised. And little wonder, in my respectful submission, because that's not what it does. On its face, it obviously talks and only talks about quantum. course, I'm not saying that Parliament couldn't have made the second major change. It could have done, but it would have had to do so in accordance with these authorities of the highest level expressly, or as a very minimum by necessary implication. But my submission is that it wasn't what was going on. The regime for collectives is procedural, just like it is in Canada. It takes individual causes of action that could all theoretically be pursued individually and allows them to be pursued collectively for the judicial economy, non-duplication, access to justice reasons that I adverted to earlier. And this is not just me who's making that as a normative submission, as if that's what should be the case. This is being decided by the majority of the highest court in the land in Merricks. Can I turn that up, please, on this point? Merricks is to be found in the Authorities Bundle number 2, tab number 16. And in the judgment of the majority, written by Lord Briggs, with which I'm sure we're all extremely familiar, picking it up at paragraph 45, and this is to be found, the sentence I want, at the top of page 616, between A and B. The majority of the Supreme Court wrote as follows: the claims which are enabled to be pursued collectively could all, at least in theory, be individually pursued by ordinary claim in England and Wales under the CPR, under the protection. And then at 46, as a similar point, between C and D, all they would need as individual claimants to establish a cause of action would be to prove that the breach caused them some more than purely nominal loss. And of course, it's trite that for a breach of statutory duty claim in this country, a claimant has to show at least more than nominal loss. One way of putting it is that no claim that didn't show nominal loss could be brought under section 47A at all, because that allows breach of statutory duty claims. And yet all that 47B does, the one that sets up the regime of collective proceedings, is it accumulates causes of action that arise under 47A. And that much is clear from the statutory provisions. I don't have the time to turn them up, but section 47B collective claims all have to be ones that are capable of being brought under section 47A, and you just accumulate them. So what I'm saying is that this is a special form of civil procedure. And again, it's not just me that's saying this. Those are the words that are set out by Lord Briggs in paragraph 45. That's 2 lines up from the bottom of page 615. He says that these collective proceedings are a special form of civil procedure. And then he goes on to say that this liability question was simply not there in the Supreme Court. It wasn't relevant to Merricks for the reasons that I've given. And this point is made clear in the first line of paragraph 46, where he states that the issues which give rise to the forensics difficulties which led to the CAT's refusal of certification in the present case all relate to the quantification of damages. So the majority doesn't refer anywhere at all to aggregated liability, doesn't mention the Mulheron article, doesn't mention the arguments that are then adopted by Lord Sale and Lord Legge. No wonder it doesn't mention these points, including the Mulheron article. That wasn't referred to in argument. It wasn't even in the Supreme Court bundles. And I've had that point checked. But in contrast, the speech of Lord Briggs is replete with references to and examples of, quote, quantification, unquote. I've counted no less than 10 such references in. You can see many of them. There's 3 in paragraph 47, there's 1 in paragraph 48. I mean, there's 3 on the next page, etc. What they were addressing was a situation in which there were issues about quantification, and these were all claims that could be pursued, at least in theory, individually, because they amounted to causes of action in their own right. This point is yet again made express in my submission over the page at paragraph 54, 2 pages further over, where in the first line their lordships say there's nothing in the statutory scheme for collective proceedings which suggests expressly or by implication that this principle of justice, that claimants who have suffered more than nominal loss by reason of the breach of defendant's breach should have their damages quantified by the court. So again, that couldn't be more express that they
Harris, help me with this. You're saying that Merricks didn't decide the liability point. They did approve of the Court of Appeal's analysis of liability in relation to pass-on, which they approved of. I'm just checking it. Paragraph 64A. That's referring back to the Court of Appeal 45 to 47, which is referred to by the CAT in 112. Isn't that an express approval of aggregation applying to liability?
My lord, no, for a number of reasons. First of all, and I will obviously get to this, I don't...
I'll take you out, of course. Come back to it when you want to.
I'll give you a brief answer and then I'll come back. For a number of reasons. The first is I don't accept that paragraphs 45 to 47 of the Court of Appeal in Merricks set out a definitive finding that you're allowed aggregated liability in this country, whether pursuant to 47C2 or otherwise. And first of all, I don't accept that when you read what they say. I don't accept that when you read what they say when one understands exactly what was going on in the Court of Appeal in Merricks. And thirdly, and most profoundly, it is clear beyond doubt that the question of aggregated liability was not a live question in Merricks, whether in the tribunal, in the Court of Appeal, or in the Supreme Court, unquestionably. And so, at the very most, if you don't agree with what I'm going to go on and submit later on this afternoon about the true meaning of 45 to 47 of Court of Appeal in Merricks, then at the very most, that would have to be an obiter expression of view about a point that wasn't an issue. At the very most, but I say we don't even go.
Your answer is you'll come to it.
I'll come to it in those ways. Yes, and of course it wasn't. Well, I've made the point. Now that the regime is purely procedural and makes no changes to the liability analysis, is also exactly what the tribunal itself had said. Indeed, through the lead judgment of none other than the same former president of the tribunal who sat in judgment in the case that I'm appealing. In the first CPO case, Gibson and Pride, that's exactly what was said in that case. The argument there, if you recall, was about imposing, one of the arguments was about imposing fresh, allegedly retrospective liability. It was said this new regime allows you to conglomerate and go back in time at a time when the defendant didn't realise that it was going to be exposed to this sort of liability, and it was said to have been a retrospective substantive liability, indeed advanced by none other than my learned junior, Mr Armitage. But it was in the context of dismissing that argument that the learned then President Roth, giving judgment for the tribunal, said as follows. The reference, I'm not going to turn it up, but for your note, the reference is Authorities Bundle, Volume 2, Tab 11. And it's paragraph 35, the tribunal in that case said, and I quote, Section 47B does not give rise to any new or fresh liability. And then at footnote 2, it says, in collective proceedings involving standalone claims, there is similarly no additional liability on the defendant. At paragraph 38, it says, such proceedings, by which it means collective proceedings, such proceedings have no legal effect on accrued or vested rights or liabilities. And then 37, accordingly, we do not accept that this feature of collective proceedings, i.e. ability to claim aggregate damages, we do not accept that this feature of collective proceedings means that they involve a change of substantive law to the disadvantage of defendants. So it couldn't have been clearer in the then President's view in that first case that this was a procedural regime that made absolutely no changes to the law of liability. To the contrary, you had to have individual causes of action and they had to be conglomerated together for procedural reasons and to allow quantification of damage in the aggregate. And yet it's now said by the tribunal to be exactly the opposite. There is an irreconcilable tension between those two cases, and in our respectful submission, the first one is right, and the later developments, based upon the obiter remarks of Lord Sales and Legat, for which I always have the greatest respect, but nevertheless they were obiter, and in my submission they were wrong. And the tribunal got it right first time round, and I, again, at the risk of labouring the point, it couldn't be clearer, the sentence at the top of page 616 in Merricks and the Supreme Court, the claims which are entitled to be pursued collectively could all, at least in theory, be individually pursued by ordinary claim. That is identical to the position that we saw at paragraphs 131 to 133 of Procedural in the Supreme Court of Canada. But it equally couldn't be clearer that changing the law substantively so as to allow for aggregate liability is self-evidently a massive disadvantage to defendants. So, moving on. What I say is that it's no good, in my respectful submission, trying to cherry pick obiter comments from the dissenting minority judgment in the Supreme Court in Merricks and seek to establish that they are authoritative statements of the law amounting to a radical substantive additional extension of the law of liability, and all the more so when that dissenting minority differs in fundamental respects from the majority opinion. So, just to take for instance, they differ completely on the question of the suitability analysis. One was absolute in the what obviously with respect is the incorrect minority judgment, and one is relative in what is obviously the correct analysis in the majority judgment. There's another big difference, which is that, of course, Lord Sales and Leggatt were prepared to extend, in their view, the law of liability, which is massively disadvantageous to defendants, but they were prepared in the other direction to be much more onerous in the test of evidence that was required. Indeed, so much so that they wouldn't have allowed the appeal in Merricks. Why they were a dissenting minority. So they have got a different view of the world, where it's going to be a lot more generous to claimants in a liability sense, but a lot less generous to claimants in a evidential sense. Whereas in sharp contrast, the majority opinion didn't address itself at all to the question of extending the law of liability. The 10 references that I've counted up are only to quantification, and indeed that's why that passage that I read refers only to quantification. But in contrast to Lords Sales and Leggatt, they were prepared to be much less onerous on the question of evidential burden. And so what I say is it would be unfair, and wrong in principle to take what Lords Sales and Leggatt set out, obiter, and draw out from them as if that's the authoritative, the decided statement of the law in those circumstances. And all the more so when the point was not argued at all. This came as a great surprise to me, even though I was delighted to win the Merricks case, to have this statement of the law, because I'd never even seen Professor Mulheron's article, or not, I hadn't read it on that point, and it wasn't in the bundles. It just was not a live issue. And what I say is that Lloyd and Google doesn't take us any further. There's, in that case, in the 5 members of the Supreme Court, there's one passing mention of aggregate liability in very brief terms, in one paragraph only, that's to say paragraph 31. And there's no indication that this, at this point, if you like, Professor Mulheron's second major point, no indication that it was argued. And I asked rhetorically, why would it have been? It wasn't relevant to that case. That case was about liability under the Data Protection Act, not under the Competition Act. What I certainly say is that the passing endorsement, because it's a very short half a sentence in paragraph 31 by the other members of the court, one of whom of course is Lord Sales in Lloyd and Google, can't be taken as being a definitive statement of the law of collective actions. That case wasn't about collective actions. So that then takes me to the Court of Appeal in Merricks. I said I'd come to this, and I recognise that I have to grapple with this. My learned friend puts a great deal of weight on it, so that you have it before you, whilst I'm making some submissions about it, you'll find it in Authorities Bundle number 2, the same one as the Supreme Court, but at tab 15. I beg your pardon, it's tab 14. And it's 45 to 47. Now, I'm going to be dissecting, if you like, the wording of those in a minute, but I just want to lead up to it, if I may. It's very important to be clear what Merricks was about in order to understand what the judgment in Merricks is about. Merricks was about whether or not loss to an indirect purchaser class in an aggregate top-down claim that concerned overcharges could qualify as a common issue at a certification stage. So let me just repeat that. This is absolutely central in my submission. Whether in an indirect purchaser class, in an aggregate top-down claim that concerned overcharges, could the loss qualify as a common issue at certification, thereby allowing a trial on the issue? The argument from MasterCard was that it could not qualify as a common issue, even in that sort of a case, because the amount of the loss to each member of the class would differ, depending upon, as I said before, how much they spent and where they spent it and what have you. So that was the argument. Importantly, the case was not one in which there were any difficult questions about the counterfactual, whether or not somebody would react differently in the counterfactual. If you bought it, you prima facie suffered a loss, and that's how the class was defined. People who bought. People who didn't buy were not in the class at all. So further, the case was a follow-on case in which liability had already been established. So they were not like our case. The appeals in these cases are ambitious and novel, standalone liability cases. It's a long way removed from Merricks, where liability was already established. And as I submitted earlier to my Lord Justice Green, MasterCard didn't argue that there was this problem with over-inclusive, aggregated liability for the reason that I gave before. It's worth repeating. They accepted that if you were in the class, then somewhere, at some point in the 16 years, you would have bought something in a retailer or merchant that accepted MasterCard. And as soon as you recognise that, then there's some more than nominal loss. And that's all that's needed at the interlocutory stage. So that was a very different case. And as you know, what we say in this case, and Mr. Jow will develop this, is we don't accept that for every single transaction there would have been in the counterfactual even a nominal loss. Because in some transactions, the boundary fare wouldn't have been bought at all. I'm going to leave that to Mr. Jow to develop the detail, but that's the basic point. And what's important to recognise is that context when we look at 45, 46 and 47, because there are some extremely close parallels with the fact matrix in Process and Microsoft, which is of course referred to in paragraph 46 of the Court of Appeal. In other words, Process and Microsoft was exactly a case of a class action by indirect purchasers who had been allegedly overcharged. And exactly like Merricks, if they had bought an item, I think it was optical disk drives or something, it was some computer part. If they had bought it and there was an overcharge, then they had at least a nominal loss. And the basic issue again was, just as in Merricks, was there a credible methodology for showing that that nominal loss had made itself into the indirect purchaser level? That was the issue. And that was the only issue. And that's what we were all focusing on when we argued this case in the Court of Appeal. In paragraph 118 of Process, and it might be worth having this open at the same time as the paragraphs 45 to 47 of Merricks. It's in a different bundle, volume 4, and it's found at tab 26. I said we looked at it earlier, but now I'm looking at 118. This is the famous 118 that's been adopted definitively into the law of England, and it's to be found on page 1007. What the Supreme Court of Canada says, that in my view, the expert methodology must be sufficiently credible or plausible to establish some basis in fact, the commonality requirement. And then critically, this sentence, it's tab 26 of volume 4, at page 1007. This sentence, what does it mean? What does that sentence that I just read out mean? Well, they go on and they say, this means that the methodology must offer a realistic prospect of establishing loss on a class-wide basis, so that if the overcharge is eventually established at the trial of the common issues, there is a means by which to demonstrate that it is common to the class, i.e. that passing on has occurred. And the rest, you'll be familiar with, I don't need to read it out right now. That was the issue in Process, and it's exactly the same issue on commonality as in Merricks. Let me just repeat it. Is there a means to demonstrate that passing on has occurred to the indirect purchaser level? If there is, in a case where it's a simple question of did you buy it, did you not buy it, if you bought it, there's a loss, that's all you need to show at certification in that sort of case. And that's critical to understanding what was going on in the Court of Appeal. That's all they were dealing with. The argument was you can't show that in Merricks, and we referred to Process and said, well, that's what happened in Process, that's how you answer the question, and that's all, and that's the answer to the question. And this same point, before I really am going to turn to the language in 45 to 47 in a minute, but just before I do so, can I show you that this point is made equally clear, if not clearer, in the subsequent Canadian Supreme Court case of Pioneer and Godfrey, and that's cited indeed in the judgment below. So we can usefully take it from the judgment below, which is core bundle number 1, tab number 6, and if you were to turn therein to paragraph 172, unless it's page, it might be page 172. Just bear with me. Yes, sorry, it's page 172 of the bundle, core bundle, volume 1. And this is citing from Vivendi, I beg your pardon, this is citing from Justice Brown in Pioneer and Godfrey, who's commenting on Vivendi, and they call it Microsoft, I call it Process, it's the same case. And what Justice Brown says, 107, indented, Microsoft therefore directs that for a court to certify loss-related questions as common issues in a price-fixing class proceeding, it must be satisfied that the plaintiff has shown a plausible methodology to establish that loss reached one or more purchasers, that is, claimants at the, quote, purchaser level, unquote. For indirect purchases, this would involve demonstrating that the direct purchasers passed on the overcharge. Additionally, showing that loss reached the indirect purchaser level satisfies the criteria for certifying a common issue, since it will significantly advance the litigation. This is a prerequisite to imposing liability upon Toshiba and result in common success, as explained in Vivendi, given that success for one class member will not result in failure for another. Showing loss reached the requisite purchaser level will advance the claims of all the purchasers at that level. So in other words, the exact issue that was live in Merricks before the Court of Appeal on a very, very analogously identical fact pattern was decided by Process and indeed further explained in Pioneer and Godfrey. And that all has to be taken into account when one reads paragraphs 45 to 47. So if we, in my respectful submission, that's exactly what the Court of Appeal is doing. It's applying the analysis of Process and Microsoft to this case. So it says, picking it up, for instance, in paragraph 46, the second sentence, but as indicated above, there is no requirement under section 47C to approach the assessment of an aggregate award through the medium of a calculation of individual loss, and the appellant's experts are not attempted to do so. In that they have the support of the Canadian authorities, which in cases like Microsoft have approved a top-down method of calculation on the basis that the level of pass on to the class as a whole will be a common issue for all individual claimants. So there's a focus on the individual and asking whether there's been pass on to all of those individual claimants, which could otherwise be described as the class as a whole. And what's more, what the Court of Appeal is doing here, in my respectful submission, is it's expressly basing itself upon the analysis. In Microsoft, that's why it cites Process and Microsoft in the very sentence that I have read out. And it's interesting, just pausing for a moment before I look at some of the other passages in these paragraphs, that Professor Mulheron, of course, says in her article, oh, well, this is a mistake by the Court of Appeal in Merricks. They've mistakenly relied upon Microsoft and Process because, of course, the mistake, she says, is that Microsoft and Process is the case that I read earlier that emphatically doesn't allow aggregated liability. So she says, well, this is a mistake. And my learned friend says the same thing. He says, oh, never mind about the mistake. The rest of it's really clear. But actually, it's not a mistake at all. Far from being a mistake, the Court of Appeal here is expressly relying upon Microsoft and Process as addressing the exact issue that was live in Merricks, as I've just explained it. And everything else that you read in these, whether it be 44, 45, 46, or 47, is entirely consistent with an analysis of only a case in which 47C2 is aggregating damages and isn't aggregating liability. So I've just read out that sentence in the in paragraph 46, and likewise, if you look at the final sentence of paragraph 47, pass on to consumers generally satisfies the test of commonality of issue necessary for certification. That's, if you like, a pithy summary of what's gone on before in these paragraphs, and it is exactly the issue that was addressed in Process and Microsoft, and exactly how it was summarised in the passages from Pioneer and Godfrey that were cited in the judgment that I just read out. So that's what's going on here. And what one can't do is seek to cherry pick out of this, and in particular seek to alter the context of this case and say that these paragraphs are addressing a different question, which is aggregated liability. There are all kinds of reasons why you can't do it. And I adverted to Lord Justice Green what some of them were before. That question wasn't live in Merricks, wasn't argued. Professor Mulheron's article hadn't even been written. I didn't advance the cases ex parte Pearson, ex parte Sims, and Ingenious Media. It just wasn't a live issue. And there's another reason why 45 to 47 can't be taken as the fons et origo of this new massive substantive change to the law so as to allow aggregated liability. And that's because I invite you rhetorically to find a single reference to liability in paragraphs 45, 46 and 47. It just isn't mentioned. It doesn't refer to any substantive change to the law to aggregated liability. And why would it?
What about the first 3 lines of 45? Isn't that what they're saying?
Well,
A critical issue in deciding whether the proposed methodology is a suitable and effective means of calculating loss to the class is to determine whether it is necessary to prove at trial that each member of the proposed class has in fact suffered some loss.
That's right.
That another way of putting the point?
I don't accept that that is a point.
Because they have to establish loss as a critical element of the cause of action.
They do.
And that's exactly the point that they're making there, isn't it? That
They
if
do,
you
my lord.
establish that, then you establish liability.
They do, my lord, but let's remember, and I apologise for repeating this, but let's remember the facts of Merricks and the facts of Process. They were that if you had bought the overcharged good, that was prima facie liability. Was it simple? If you'd bought it, it's prima facie liability because the case was they were overcharged. Simple as that. And so the question here is, where you've got that fact pattern, do you need to do anything other at the certification stage of asking whether there's a common issue than say, has there been some penny of loss that somehow made it to the indirect purchaser level? Answer, very clearly, no you don't. And the reason is let's compare it with an individual claim. In an individual claim, you wouldn't have to do any more than that either. You would come along and you would say, well, you know, my contention is that I spent £3 million on 400,000 types of goods in the 16-year period and I want, whatever, £1 million of damages. But to get past an interlocutory strikeout phase at which the defendant says, no, that's incoherent, all you would have to do is say, but I've got a prima facie case, I've got an arguable case that I've got at least a penny of loss, I've done one transaction. And then as Lord Briggs points out in Merricks and the Supreme Court, after that, off you go. You try to prove all the remainder of your loss, whether it be with exiguous evidence or with quantification methods like extrapolation and what have you. And that's all that's going on here. And I don't accept, well, I take the point, and I recognise that those words can be read in different ways in the first sentence of paragraph 45, but they do not say anywhere liability, and they certainly don't say, I'm addressing the question of whether section 47C2 allows aggregated quantum as well as aggregated liability. And even Professor Mulheron says, and this is her thesis, this is what she wants to see, with respect to her, that's fine. She says, at best, it's implicit that that's what the Court of Appeal is getting at here, at best. And then she even laments that it could have been a lot clearer. Well, with respect, my submission is that it's not implicit, and it isn't clearer because they're not addressing that issue. Simple as that. So that's how I deal with 45 to 47. And I recognise, I would be daft not to do so. I recognise that there are words in there about that can be interpreted or give rise to some confusion. But ultimately what it comes down to is they can't have been establishing this new substantive change in the law of the land from massive disadvantageous extension of the principles of liability, disadvantageous to defendants, implicitly. And if they had done, it was obiter because it wasn't a liability.
When you say disadvantageous, can you just explain precisely what you mean, given that the CAT said you can make all the necessary adjustments through the aggregation process to ensure an absence of over-recovery?
Well, when you put it like that, my lord, if it were the case that you could properly take out in an aggregated liability the ones, an aggregated methodology, the ones for which there was no liability, then that would be potentially acceptable in a world in which Section 47C2 allows aggregated liability. If. But as you've heard me say, and as Mr Jowl developed, there are some cases where you can't do it, and this is definitely one of them. So that's the answer to that. And so essentially, that I really don't have much more to say about Lord Sales and Legatt's minority remarks. I say that that's wrong. That it wasn't argued, it wasn't addressed. Professor Mulheron's article wasn't even there, let alone argued about. And they've taken upon themselves to express their view of what it might mean. But they haven't addressed all the cases I've addressed. They haven't all of these reasons. But what I would finally say on this submission, before turning to the second major one, and then obviously finish off with grounds 3 and 4, is that even if you're against me as regards Lord Sales and Legatt, and whether this submission I'd be making is correct, can I just please draw you to 3 further remarks in their minority judgment that are helpful in the context of this appeal. They are to be found, so this is bundle number 2 of the authorities at tab 16 at page 635. And the first passage, there are 3 quick passages, is to be found at the bottom of paragraph 121 in the minority judgment. And Lord Sales and Legatt, whatever view one takes and judgment that this court comes to about aggregated liability, they do say at the bottom that when there's an assessment to be carried out, a method has to be available which can be used to assess loss suffered by the class as a whole with a reasonable degree of accuracy. And then likewise, the last sentence of para 123, the methodology has to be, quote, capable of establishing loss in a reasonable and a just way and at a proportionate cost on a class-wide basis. And then last but not least, a few pages further on at paragraph 154, the first sentence, if the applicant could not show that there was a realistic prospect that his expert's proposed methodology would be capable of application in a reasonable and fair manner across the whole width of the proposed class. So what I say, and it's sort of segue...
paragraph is that, Mr.
I beg your pardon, my lord?
Which paragraph?
154, the first sentence of 154. Yeah. So what I say as a segue, if you like, into my second submission is that whatever view one takes about this major point, what does section 47C2 mean? Is it 1 substantive change or 2? Even with respect Lord Sales and Legatt, with their more expansive view of the world about aggregated liability, they were saying, well, whatever you do, you can't end up with something that's not a fair and reasonable methodology for aggregated damages across the whole width of the proposed class. And that's relevant because as I'm now going to turn to some overview points about why you need a methodology that's capable of extracting prima facie over liability, that's relevant because they're in my respectful submission, they're saying, well, as a minimum, you've got to have that. You've got to have a fair, if you're going to do it in aggregate, as we say you can, as a minimum, it's got to be reasonable and fair across the whole width of the proposed class.
In relation to methodology, I know you're coming on to this. Maybe I can just sow this as a question to answer as you're going along. Presumably, do you accept there's an asymmetry of information as between claimant and defendants? One gets this in lots of areas of law: quantification of damages, minority shareholder prejudice actions. The law adjusts to take account of the fact that information relevant to a point of law is in the hands of one party as opposed to the other. To what extent can you expect a claimant in these sorts of proceedings to have access to data sufficient to put forward a methodology which would satisfy your test?
Yes, I'll answer that directly and straight away. The answer...
At the certification stage, yes.
I'll answer all of those points directly and straight away. The answer is under paragraph 118 of process, you don't have to have the data, you have to have, and I quote, evidence of the availability of data, unquote.
How do you know what's in the defendant's possession?
First of all, you don't need to know what the data says in order to be capable of saying that evidence of that type exists. And indeed, this case is replete with examples where Dr. Holt, the expert for my learned friend, Mr. Moses' team, he says, oh, well, don't worry, I expect that the defendants will have that type of data and I'll get it. And that's a perfectly fair point. Nothing in this case revolves upon that. So that's the answer to one part of your point. The second part is it's very important to understand what I'm submitting here. This is not an onerous thing that I seek to suggest that a PCR has to do at a certification stage. I base myself foursquare upon paragraph 118 of process. All I say that they have to do at the certification stage is if they begin life with a top-down aggregated methodology that prima facie is liable to lead to over-inclusivity precisely because it is top-down. I mean, that's kind of the gist of top-down. If you're in that situation, then all you have to do at certification, in the same way, all you have to do is you have to say, dear judge, I've got a credible and plausible method for showing to you now that later on I will be able to extract the non-liability situations. That's all you have to do. But you have to do it at certification. And in a moment I'm going to show you two US cases where that is exactly the law that they expound on. They've addressed themselves to this precise topic, and it's the law because of fairness. It's got nothing to do with procedure or US class action rules or anything like that. So that's the answer, my lord. Lord Justice Green. So it's just to summarise. You don't have to have the data, you just need to have evidence of the availability of data. You only have to get something that's credible and plausible. It does have to be grounded in the facts of the case. That's another citation from 118 of process. It can't be just total make-believe. But that's not an onerous hurdle. But what you can't do, in my submission, is you can't arrive at certification where you've got a prima facie over-inclusive aggregated liability methodology and then say, when it's pointed out, as we did in this case, oh, well, don't worry about that, I'll sort that out later. Well, don't worry about that, I'm an expert, I'll be able to figure it out. Or, as you'll hear me submit later this afternoon, don't worry about that, I'll do a survey. Or, don't worry about that, maybe I'll do some other kind of analysis.
But in this case, you've got all the categories where you say there was no loss or where there's a dispute, which is summarised by the tribunal in para 126. So you've got that list.
Yes.
What more do you need? You've got a list. These are the matters in dispute. On each of those, you presumably will have very relevant evidence, and you can say the category is X. What does one need?
If you don't mind, my lord, I'm going to, unlike all the other questions that I've sought to answer immediately, I'm going to leave this one to Mr. Jowl, because he's going to go through, amongst many things, why the burden is upon them, why the 7 scenarios in 126 are good points, and et cetera, et cetera. I don't want to tread on this.
Very wise. He's smiling beatifically. So he's looking forward.
The first time I've ever seen that while I've been submitting next to him.
It's not a pleasant sight for them.
So there we go. But what I want to do, if I may, is I want to develop two overarching sets of points before Mr. Jowl addresses you on your para 122 and what have you. And they are this. First of all, very, very trite. You can't have overcompensation. That's not the law of this land. I don't even need to turn up Sainsbury's for that, or for that matter, Merricks. But what I do say, that where you have a top-down aggregated liability world, there's a real danger that in certain subcategories of cases, there's a real risk, and the real risk can be discerned at certification, that some transactions or some people will be included who don't actually have a case. They don't have an individual cause of action because they can't show even an arguable case of nominal loss.
But that's over-inclusion. That's over-inclusion.
Over-inclusion. Yes, over-inclusion. I run them together, my lady. I sometimes say over-inclusivity or over-liability or over-compensatory. From my perspective...
It's the same, because theoretically they're a bit different, aren't they?
Theoretically they're a bit different, but for my purposes they convey the same point. So I'm glad you picked me up on that. But when I use those phrases, that's what I mean. And what I say is that there are going to be some cases in which the fact pattern is such that you can't actually extract, by way of an aggregated methodology, the non-liability situations. And those are the ones that shouldn't be certified to go on. You can see at certification that you won't be able to do it. Or put the point more accurately, because that's unfavourable to me the way I've just put it. Put the point more accurately, that the PCR can't at the certification stage come and show to the tribunal that it can, with a credible and plausible methodology grounded in the facts for which there's evidence of the availability of data, take out the over-liability questions. And it has the burden, as Mr. Jowl will develop. But it's important to be clear here that this is, and I quote here on this point from a case that I'll be turning up in a minute, Dennis and the Ontario Lottery and Gaming Board, that the distinction is, and I'm quoting here from paragraph 54, In these cases, liability essentially turns on the unilateral actions of the defendant and is not dependent to any significant degree on the individual circumstances of the class members. So what I say is, even in an aggregated top-down liability case, where where you could take out prima facie over liability situations, non-liability situations, by just looking at the actions of the defendant and using the defendant's data, no problem. But they're not every case. There are some cases, like the facts in these appeals, where actually the liability doesn't depend unilaterally upon the actions of the defendant, doesn't rely entirely upon the data of the defendant. On the contrary, they depend upon the actions of the claimants, the individual claimants, and this is that case. And those are the cases where, at the certification, this court, in the exercise of its duty to perform what Lord Briggs called the gatekeeper role, has to deny them. But let's be clear. My learned friend says, in his skeleton, oh, well, if Mr Harris and Mr Jowl are right, that would render this regime impotent. It would render it unworkable. Those are his two adjectives, impotent or unworkable, but nothing could be further from the truth. Let's be quite clear what I'm talking about here. I'm talking about a subcategory of a subcategory of a subcategory of case that may fail in the same way that this appeal fails. Well, the appeal succeeds, but the case should fail. The subcategories are this. These problems arise in top-down cases, but not every case is a top-down case. Quite a lot are not. These points don't apply to them. These submissions that I'm making apply to opt-out cases. But not every case is an opt-out case. Just last week a massive case was certified as an opt-in case. And then thirdly, so those are the first two subcategories. And then the third...
It may be that in the light of Le Patrol, there'll be a lot more opt-out cases than there have been in the past.
Maybe. But what it is said...
That's the whole point that we grappled with there. Where you've got very small claims by individuals. There's not much incentive to pursue your individual claim. So that opting in is not really particularly sensible.
I accept that entirely, my lord. I don't have any
Anyway,
disagreement.
I get your point that it's a sub.
Well, it's three subcategories. So the first one is top-down, second one is opt-out, and the third one is it's only in particular fact patterns that it matters, even within those first two subcategories. So take Merricks, for example. Merricks is an opt-out top-down, but it doesn't have this problem. Ours is an opt-out top-down, but it does have this problem. And why? What's the difference? Well, the difference is that the liability critically hinges, in my case, in these appeals, on the reactions and actions of the individuals with what is said to be happening in the counterfactual world. But in Merricks, it doesn't. Lots of cases will be of the Merricks variety. Take BT Le Patrol, for these purposes, sufficiently similar. That's my point. So it's just wrong to say that if I'm right on these points, that somehow it renders unworkable or impotent the class actions regime. It just doesn't. And what's more, of course,
It'll be said against you, I think, that if your clients had properly advertised the availability of boundary fares, the vast majority of people would go down that route because nobody wants to pay more money for something than they have to.
well, my lord, Mr Jowl is definitely going to deal with that because, as you know, we don't accept that is a premise that is sufficiently reasonable and fair in the facts. But I don't want to tread on his toes. You will.
No, I know, but I mean that's a point that, certainly speaking myself, I need considerable assistance from somebody on, because it just seems to me the common sense point that the CAP makes is entirely correct. Well, if I buy a train ticket, I was saying before we came in, if I go online, as I do, buy my train ticket to go home once a week, the first thing I do is to feed in the fact that I got a senior rail card. I don't intend to pay a full fare.
Well, my lord,
you instinctively you always want the cheapest option.
Well, my lord, I'm not going to tread on Mr Jowl's toes, but can I respond to that point? You may do so, my lord, but it transpires that in the real world a lot of people don't.
Well, maybe you're right.
No, and we know this for fact. We know this for fact because boundary fares have always been available. And the hypothesis from my learned friend is that they are cheaper and they should have been bought. But lots of people, on his case, didn't buy them. We're talking lots of people. So they're all in your shoes.
Well, I never even heard of them until this case.
Well, maybe, but anyway, I don't want to overstep the mark. But our point, and Mr Jowl will develop this point, is that it is certainly not the case that it can be taken as read that in every situation in the counterfactual,
We will hear from Mr Jarman.
as a minimum, there's a real risk that many people wouldn't, and that destroys this fact pattern. Unlike Merricks, and unlike Process, and unlike BT Le Patorel, they're all fine, but this one isn't. So what I want to do now is I just want to address you on another reason why it doesn't destroy the regime. So what it is said is, if you have to have this methodology that take things out, that's not going to work. But let's just think about that for a minute. There could be, and there could easily be, as there is in Canada, a regime that works whereby the collective or common parts proceed as far as they can, and then they come to an end. And at that point, if there are still some individual or differentiated issues that arise, they can then be dealt with then in a different way. So this is, if you like, a two-stage process. And I unapologetically advance this two-stage process because this is how it works in Canada, in a regime that works perfectly well. Indeed, as I cited from the judgment, paragraph 11, the best model that we were said to regard in this country as being worth emulating. That's how it works there. And what you have in that jurisdiction is you have, let's say there are certain common issues or collective issues, then they can be dealt with collectively. But then if it turns out that thereafter there are some more differentiated issues, whether they go to liability or quantum or both, then they are dealt with at the next stage in a stage 2 trial. And it doesn't necessarily mean, and this is another bit of, with respect, scaremongering by my learned friend. Doubtless I would do the same if I were in his shoes, but it is scaremongering. What he says in his skeleton at paragraph 21 is that that's preposterous because, quote, it would lead to individual trials for each of the 3 million or so class members, unquote. But that's just not right. That's the scaremongering. It doesn't mean that if you've had a collective trial on some major issues that are properly common about liability. Let's say, for instance, you've got a case in which there's a cartel and you need to ascertain for liability purposes what the cartel behaviour was. Or partly the cartel behaviour is set out in some agreements. You need to construe and understand what the agreements are in their factual matrix, etc. All of those are common issues and they could very well and sensibly be done in a stage 1 trial that, number 1, promotes access to justice because the individuals wouldn't be doing it by themselves. It promotes judicial economy because it avoids duplicative fact and finding. And if it goes against the defendants, it will promote the punishment and deterrence objectives. That's all entirely consistent with the regime. But what it doesn't mean is you have to have a regime in which there is an all-singing, all-dancing single trial all the way to the very, very end for every single individual. It doesn't say that in the legislation. There's no reason it has to work like that, and it doesn't work like that in Canada. There are some cases where you do what you can at stage 1 and then there's a stage 2. And let's also be realistic here. Let's say you have a case in which a defendant has failed on these big common issues, questions like the construction of the agreements and the cartel behaviour and the what have you. And you've got a defendant there who's reeling from a large trial at which it suddenly is genuinely facing, staring down the barrel of a massive action against it. And it's already, by definition, had to pay a very significant cost bill because it's lost ex hypothesi on this common issues trial. And in that context, it's unreal to think that there would then be, the defendant would then insist on having 3 million or even 3,000 or even 300 individual trials. There are all kinds of other ways forward. First of all, there could be test cases, or there could be groups of test cases. And secondly, there could be ADR. You won't forget, I'm sure, members of the court, that Lord Briggs expressly refers to the relevance of ADR in this context at paragraph 74. And all I'm saying is that is a perfectly coherent regime. It's the one that you have in Canada. And experience in Canada, so I've been told, is that not many of the cases that go past the first stage common issues trial then actually go on to fight these second stage trials, let alone 3 million of them. And that's because in the real world, people see the light of day. And in any event, my lord, my lady, I wouldn't accept that there's a problem if it turns out that there are some cases where the fact patterns are such that they are not suitable, they're not appropriate, they're not in this non-overcome compartmentalised way, not cases that should be certified. That is the meaning of a gatekeeper function. It would be, to take a phrase from Process at paragraph 103, if there weren't some such cases, of which I of course say this is an example, that didn't get through, this would be, quote, symbolic scrutiny, unquote. In my respectful submission, if this case goes through, then there aren't going to be any cases that don't go through.
Can I, on your analysis, would the CAT have been entitled to do as follows? To certify on an opt-out basis the issues that it has certified, save for those which is listed in paragraph 126, which are the exceptions that you have identified, leaving that to a second stage where it could take a series of test cases or specimens in order to decide liability in that rump, which might only be, on, at least on the CAT's analysis, a very small percentage of cases? Or was your argument that these bring the entire edifice crashing down?
They do, and that's because of the way in which Mr. Holt has chosen to proceed. Mr. Holt's method...
He doesn't face this problem if you carve those exceptions out.
No, but therein lies the rub, and Mr. Jow will develop this. He doesn't have a methodology for taking them out. His case essentially is, don't worry, I'm an expert, I'll be able to do this.
But according to paragraph 126 of the CAT judgment, these are categories that you, the defendants, have identified, presumably upon the basis that they reflect data in your own possession, but manifestly not in that possession of the claimants.
No, I wouldn't accept that way of characterising, my lord. The way in which I frame that issue is that it's for Mr. Holt, on behalf of the PCR whom he represents, to come along at the certification stage and say, I've got a credible and plausible methodology, grounded in the facts with evidence of the availability of data, that does, including what Lord Sales and Legat advocate, have to have a reasonable and fair manner across the width of the whole width of the proposed class.
That's a case management matter for the tribunal.
No, my lord, absolutely not, because the problem that they've got in this case, and in any case in which there are individualised bespoke questions of liability setting this up, is they don't know, and nobody knows, because nobody knows quite how somebody would react in the counterfactual world. And that's an individualised question. Let's say we did this on an individual basis, and I was the defendant, and you, my lord, were the claimant, and you say, I've lost out. And I might want to say to you, Lord Justice Green, if I'm cross-examining you, you say that you would have bought that particular boundary fair in the counterfactual when there was more evidence available, but actually you were in a real big hurry that day, weren't you? And you were being reimbursed anyway, weren't you?
Could the CAT order disclosure in advance of making a certification decision, so that it was thereby empowered to determine what was a common issue on your analysis?
It could in theory, yes. The CAT guide says it discourages advanced disclosure applications, doesn't rule them out, but as you know from BT to Paterel, the CAT guide is an evolving document. But yes, in theory they could. But what it is incumbent, and Mr. Jow will develop this, is it's incumbent upon my learned friends team to do this. It's not incumbent upon me to come along. I raise the prospect of realistic risk of non-liability situations. I've done so in 7 scenarios, and the problem is that he can't and hasn't addressed them in the manner that's process compliant. And my lord, I just briefly want to touch on Lloyd and Google, because I was just developing the point that it's perfectly reasonable in my respectful submission to say that you could have a 2-stage process in which a lot of progress is made, consonant with judicial economy and non-duplication and access to justice and all of those other things, even though you don't get all the way to the end. So in Lloyd and Google, the members of the courts referred 3 times to bifurcation. And what they meant by that in the context of the CPR 19 regime was that you could bifurcate in the sense that you could do a common, I paraphrase, but essentially a common issues, common issue as to the liability under the Data Protection Act, so as to lead to a declaration. That's what Lord Legat gives as an example in that case. But what he means by bifurcation is, for the reasons that are given in that judgment that I obviously don't need to develop, you couldn't go all the way beyond the first stage of the bifurcation so as to, in a common sense, have the individual damages assessments assessed for the reasons that he gives. But what he doesn't say is that, oh, well, that's ridiculous. If you can only do the first stage of the bifurcation, you shouldn't bother at all. Quite the contrary. What he says is that is a regime that is expressly to be construed in a purposive manner, so as to give the maximum degree of access to justice to the persons who wish to be in that representative claim. He says those things in terms, but notwithstanding that, there's only so far you can go. You can't go all the way to the end in an all singing, all dancing, all bells and whistles trial so as to end up with individual amounts of damages for the persons where the individual issues are too bespoke and individualised. So what I say is, if it's said back to me, oh well, that's ridiculous, that will undermine the regime if in certain cases it could only happen in two stages, and I say no, it doesn't. First of all, it happens in Canada. Secondly, it's exactly the sort of thing that was in a purposive regime that was approved of in Lloyd and Google. And what I also say is, and this is a peculiar aspect, if I may put it like this, of this particular case, is that the rules, the tribunal rules themselves, contemplate up to 2 or more than 2 stages. And this is dealt with in the judgment. I would just like to turn this up, members of the court, because in my respectful submission, there is an oddity and or an error in the judgment on this point. So I'm in Core Bundle 1, the judgment of the tribunal below, and I'm in and I think that's at tab 6, and I'm in paragraph 108, which is to be found at page 174. And at paragraph 108.2 at the bottom of page 174, the learned tribunal makes the point that I've just been making, that the approach of the Canadian courts has frequently been to segment the proceedings between a common issues trial to be followed by trials of the individual issues. Well, exactly my point. But then it goes on to say, although that is certainly possible for collective proceedings in the UK pursuant to Rule 74.6, again I agree, see the guide, it is not expected to be the approach where the class representative puts forward a tenable claim for aggregate damages. Oh, why not? There was no argument on this point, there's no reasoning behind the point. In my respectful submission, where there are the individualised and bespoke issues that arise, it's all the more important that you should be contemplating potentially a second stage for those issues that aren't truly and properly and credibly or plausibly said to be common issues.
Well, I think it's really, you have to read 2 with 3, don't you? Because they go on to say related to is the
Yes.
point about aggregate.
I accept that, my lord.
Aggregate liability. That I suspect it's really part and parcel of the same point.
I accept that, my lord, but you have my submission that I say
I
3
accept.
is wrong. 3 is wrong. Anyway, what I'm going to do now in the time available is I'm going to finish off my points on, if you like, this second submission by reference to some brief references to some cases, and then in the time remaining I'm going to deal with my respectful criticisms of the survey methodology, and finally the appeal against the strikeout. So that's the roadmap for the remainder of this afternoon on my feet.
Yeah. And will you help us with where our jurisdiction over points of law ends and issues of discretion for the tribunal start?
I certainly will when it comes to the critique of the methodology, because it's said squarely against me there, and I recognise the remarks that were made by this court in Le Paterel that there is a limit. But so I'm going to very expressly address that. But on these first 2, it's obviously a point of law whether you can have aggregate liability or not. We say that it's equally obvious that if you've got a methodology that fails to comply with the process test because it's not capable, and let me reverse that. The PCR hasn't demonstrated at the certification stage that there's a credible and plausible way of taking out the over-liability situations, then that's an error of approach, an error of law. So that's what I say about the first 2. But the third one, where it's slightly more hard, I will explain how I say that's an error of law. And then my strikeout appeal is, you will see when I make the submissions. There's jurisdiction to deal with them, that's obvious. Okay, so what I'm going to do now then, there are 4 cases. There are 2 Canadian cases called Dennis and the Ontario Lottery and Gaming Board, and then Muteros and DeVry colleges. I'm going to deal with them very briefly because there's not time to deal with them at any length. And then I'm going to deal very briefly with 2 US cases. One's called INRI Nexium and one's called INRI Asacol. All of these 4 cases are dealt with in the judgment. I made submissions on them below, and I say with respect that the errors in the judgment are that the tribunal, with respect, didn't understand the points that were being made by reference to the cases. So let me set them in context. Dennis and Muteros, the reason I refer to them is because they are both cases in which there were far too many individualized and bespoke issues going to the liability of the individual class members to make it, whether one calls it appropriate or sensible or suitable or just or fair or reasonable, to make them collective. There was too much individuality in each of them to make it sensible in that sense to proceed collectively. That's what those two are. And then the US cases, they stand for a different proposition. They recognise, the both of them, that where you have a class in which there is at the minimum a real risk that some people haven't got liability, can't establish liability for certain transactions, then at certification you have to be able to show how those transactions will be taken out. So that's that's why I'm doing this section of the oral submissions. Now, Dennis and the Ontario Lottery and Gaming Board is to be found in Authorities Bundle, Volume 3 at tab 25. And I'm afraid I am going to do this rapidly for obvious reasons. It was a case in which people signed voluntary exclusions from gaming facilities in Ontario. And then, having nevertheless signed them, some of them went back to the gambling facilities and lost money. And then they sued, saying that it was the gambling board was liable for the losses that some of them had suffered. And the thrust of the case in the Ontario Court of Appeal, thank you so much, was that it was too individualised to allow, in a sensible, just manner, a common issues class proceeding. So picking it up, the way it worked is there was a motions judge at first instance, and then there was a, I think, divisional court at second instance, and then it went to the Court of Appeal. So when you see those references. And what the motion judge said relevantly is first to be found at paragraph 30, which is on page 943 at the bottom of tab 25. So the first instance judge at para 30 said, it rejected the contention that the problem of the heterogeneity of the proposed class could be overcome by statistical evidence, indicating that approximately 87% of self-excluded individuals would be likely to be pathological gamblers. The motion judge explained that OLG's liability could not, quote, be determined on the basis of statistical probability, as the CPA is a procedural statute that, quote, does not abrogate the requirement that a defendant can be found liable only to those persons who can prove their claim. As we'll see, the divisional court agreed and then the Court of Appeal agreed. But that's important because that was one of the points that you put to me, my lord. In Canada, you can't do this. You can't say at the common issues trial, well, don't worry, I won't look at the individual circumstances, even though you say they're all bespoke and they might go this way or that way or the other way on the facts. Don't worry about that. I'll just take a broad brush statistical approach. Maybe 20% of the people would have done this, 30% of them would have done that. That's not allowed. And that's the reason, because it abrogates the requirement that a defendant can only be found liable to those persons who can prove their claims. And the motions judge is further explained at 32, explaining that whether or not OLG breached its duty to employ its best efforts, and I just pause there, that's quite similar to our case. This is a case in which the allegation against OLG was said to be, oh, you haven't done something to your best efforts, but if you had done it to your best efforts, then you would be liable. And OLG said, well, hang on a minute. Even if I'd done something to my best efforts, in the counterfactual world where these best efforts are being done, it doesn't follow that I'm liable. There might be all kinds of other outcomes. And that's what this paragraph is saying. It says it's an individual inquiry. Picking it up 5 lines down, the issue of causation would also require an individual inquiry into whether there was a causal link between the losses incurred by class members and the alleged breaches by OLG. But exactly, that's exactly my case. And it led to the conclusion that you couldn't have a class action in this case. So if you turn over the page at 945, this time under the heading Divisional Court, Majority, you can see that these points are essentially repeated at paragraphs 37, 38 and 39. It's too individualised. You can only decide liability by reference to the individual circumstances. The first line of para 39 sums it up. The issue of liability for breach of duty of care is also individual. And then the last line of paragraph 39, moreover, there will be significant individual issues involving contributory negligence and causation. Again, exactly the same as my case. And although in our skeletons and in our oral submissions we are focusing mostly on the causation, as you said, as you've seen from my skeleton in particular, these points apply in my case just as much to contributory negligence. They're all individualised. You can't tell except by looking at the individual facts. And then at 41, there's again dismissal of statistical evidence. It says, quite apart from the frailty of the studies underlying the appellant's statistical evidence, that 87% of those who sign self-exclusion forms would be pathological gamblers, the CPA does not permit it. And yet that's a regime that works perfectly well. You've heard those, you know my point. Anyway, it goes on, and then the Ontario Court of Appeal comes to the same conclusions. I'm not going to read them out, but I rely in particular under the heading analysis on 947, 948, and 949. It's all worthy of reading, but they all say, and this is where I got the passage that I did quote before, so I'll just take you to this. At 948, underneath all of those indented citations, do you see the line that begins by the first hole punch, in these cases? In these cases, liability essentially turns on the unilateral actions of the defendant, is not dependent to any significant degree on the individual circumstances of class members. And that's why I made that submission earlier, because I said I'd come to it. Okay, so that's all I have time for with Dennis, but I say it's an extremely close analogue, and it was wrong for the Learned Tribunal essentially to dismiss it as being distinguishable on the facts. I do accept that there were all manner of causes of action there, above and beyond just breach of contract, and they were all ruined for class action purposes by the individualised nature of the claims. But that doesn't matter whether you have one cause of action or five. If it's ruined by the individualised nature, it's ruined, even if you only have, as in this case, one potential cause of action. And then muteros, I'm going to take this one even more briefly. Muteros is to be found in the same bundle at tab 23, and it was a case in which a proposed class action of students were wanted to sue the DeVry College Group on the basis that the DeVry College Group had made various alleged misrepresentations about their employment prospects and earning potential, etc., once they graduated. And what happens in this case is, again, the court in Canada, this time the Ontario Court General Division, rejects it as a case that's suitable or appropriate or just or fair for a class action, and that's because of the individualised nature of the issues that arise in seeking to determine liability and damages. So what they say, there's a useful bit of the facts on page 897 by the two hole punches. There are lots of students and they all did lots of different things. So in the counterfactual world, they might have all done lots of different things as well. And then if we go over the page to 900, I'm sorry this is so quick, but it's the constraints of time. At the bottom of 900 and the top of 901, you'll see that there was a massive differentiation between the nature of even the alleged misrepresentations. Would they have come from this source, that person, that source? Exactly the same as our case. Exactly the same. Who knows in the real or the counterfactual world where somebody would get this better information that my learned friend Mr Moses says my client should have made available or sufficiently available. And who knows how they would have reacted to it, if at all. Who knows whether they even cared about it, if at all. And who knows whether it would have made any difference to what they were going to do. And the way that's expressed in this case is on page 903 by reference to the familiar concept of reliance. Obviously, reliance being an element of the tort of misrepresentation leading to damages. But it's analogous to our case. What it says between the two hole punches. I'm now on 903, my lady.
Yep.
Reliance is an essential element of the tort, but the question of reliance must be determined based on the experience of each individual student and will involve such evidentiary issues as how the student heard about DeVry, whether the student saw any of the advertisements, and if so, which ones, what written representations were made to the student prior to enrolment, whether the student met with an admissions officer, whether the student relied on some or all of them. The inquiry will not end there. It goes on to say that it'll make a difference to damages. But that's the analogy, my lady. In this case, let's say in this hypothetical counterfactual world, my clients have made available, or sufficiently available is the allegation, some more information about types of ticket. It doesn't follow that that would have necessarily led to somebody buying that type of ticket. They might not have relied upon it. They might have got it from a person at that ticket counter, but not on that particular transaction on that day, but not a person at a ticket counter in a different station on a different day. They might have been reimbursed in one day, but not another day.
Just looking to see what the tribunal said about it. I mean, they cite the bit you've just cited,
Yeah.
paragraph 86 cat judgment. They draw together all the threads at paragraph 107 and 108, and they only come to the conclusion that there may be, that facts don't have to be identical for there to be commonality. There may be enormous nuances in the facts of different cases. And I suppose it really just leads to the fact that every case is confined to its own facts. I'm looking at 107, 1, 2, 3 and 4. I mean, in this case, I mean, the conclusion of Judge Winkler was, quotes from 904, such a class action will be completely unmanageable. That was his view of the facts for the reasons you've just given. The tribunal took the opposite view in the present case on the facts. They thought the exceptions would be relatively small. People who would the carve-outs, if you like. Isn't that just a difference in fact?
Well, my lord, my submission about these cases is, and their dismissal and distinction by the tribunal below, is that what they showed was an instinctive reluctance in the context of this regime to recognise that where there are cases with two individualised issues going to liability and causation, that it was perfectly acceptable for some of them, my subcategory of my subcategory of my subcategory, to fail. But when I do accept that if you put to me that, well, each case is different and the facts are different, of course I accept that. My submission, of course, is, and the reason I draw that, you know perfectly well, is my case is more analogous to these that didn't succeed collectively for the reasons that I've given, and that's why I rely upon them. Yeah, so,
the difficulty is, and as my lord has put to you, where you get to the end of 115, where they've dealt with these authorities, they say, by contrast, in the present cases where the claims are for systemic breaches, what we regard as the common issues as set out below appear much more significant than individual issues. So they are there making an evaluative judgment on the facts that the common issues far outweigh the individual issues.
well, I have two answers to that. The first is that Mr. Jowl will be developing all of those 7 scenarios in 126, but you will have noticed that some of them are dismissed, we say wrongly, as being, without any foundation, allegedly de minimis. There's no evidence to that effect, and it's an improper finding. And so for the tribunal, against that background, to say in our evaluative judgment, oh, well, this is not a case where it's over that line, whereas those other cases were, and that each case is different on its facts, that would be an erroneous finding. All I need, as you've heard me say, is to establish at certification in response to the PCR's application for a CPO that there's a realistic prospect that his methodology won't be able to cater for these non-liability situations, and then it's up to him, and Mr. Jowl will develop that. But so before I turn to the last two sets of submissions, then there are just these 2 US cases. So again, this is going to be very brief. What they stand for is the proposition that where you have a case in which there's a realistic prospect in which the top-down methodology is over-inclusive because it includes alleged liability for counterfactual situations where in fact there would be no loss, no liability, then at that stage, for reasons of fairness, you have to be able to show to the certification court that you've got a method for taking them out. And if you don't do it at the certification stage, you fail at the certification stage. And just by way of introduction, the background to that is, one can see why. Because it would be a farce, in my respectful submission, to then proceed to an extremely expensive, time-consuming and difficult common issues trial without knowing that there's at least a reasonable and plausible prospect of being able to take out the over-liability situations. And then at the end of the trial, it turns out that the defendant was right all along. And you can't have a meaningful, fair and just aggregate outcome because you've not taken out. Then the whole thing will have been a waste of time. And that's a terrible waste of resources, the exact opposite of judicial economy. And what's more, it's the exact opposite of access to justice. Because in allowing that claim to proceed to a failing aggregate trial, you've denied access to justice to all the other people who would have been in court during the time that's been spent dealing with this humongous trial that fails. And that's the rationale. So it's fairness to defendants. They shouldn't be exposed to an alarming and potentially overly burdensome, I think that's a phrase that Lord Sales uses in Merricks and the Supreme Court, gargantuan opt-out, top-down class, if it can already be seen that the PCR hasn't been able to establish a realistic and credible prospect of taking this problematic set of transactions out. That's the rationale. And these two cases are both what we on this side of the pond call the pay for delay cases. So the counterfactual problem is absolutely obvious. They are that even if the generic company had entered the market at a cheaper price, it simply does not follow, and this picks up to some extent, my Lord the Chancellor's remark, not everybody always buys the cheapest thing. Now, I appreciate drugs and train tickets are a bit different, but the point to illustrate is exactly the same as a matter of principle. In pay for delay cases, even when the generic comes on the market, it transpires there's at the very least a realistic prospect that a lot of people are not going to buy it, even though it's
those are
massively
different.
cheap.
I mean, I remember doing those cases years and years ago when there was a huge amount of psychiatric evidence before the court as to the impact of branding upon patient buying practices. People felt that an unbranded product just wasn't going to do them any good, illogical and irrational though that was. I mean, this is the same ticket, the same brand. I mean, is the tribunal, you've got to establish that the tribunal was acting almost irrationally in applying provisionally for certification only, coming to a conclusion that the vast majority of people want to pay the least for the product or the service. And at the certification stage, provisionally, pro tem, how can that be wrong?
Not cutting you out from establishing the contrary proposition at trial.
Well, my Lord, you are, because how am I going to pick up on that point, how am I going to establish that a particular individual wouldn't have bought the boundary fare at that ticket counter on that day in the counterfactual world for that journey when nobody has any idea who the individual is?
You're going to
Well,
do
my
that?
learned friend doesn't produce a survey of
Well,
you could produce a survey that demonstrated that in 75% of cases people are quite happy to pay more money than they're actually obliged to pay, and you say, well, bingo, there we are.
well, my Lord, I don't accept that for all kinds of reasons, including that reverses the burden of proof.
No, I understand that, but the Lord's putting to you simply the point about whether the tribunal were wrong to accept that the class representative has established sufficient at certification. But he's making the point, which is that when it comes to trial, everything is open, as it were.
But it's not, my Lord, for this reason. My learned friend doesn't know who his clients are. I don't know who they are. They'll never be at trial. He's got no intention of calling them. He's never going to get any disclosure from them, and yet these are individualised issues. It's for my learned friend, once I've raised a realistic...
You're right, it's different in this case. If you lose on the certification stage, it's no longer individualised, but you can establish aggregate, no loss. You can say, I can't go and ask each one of the 4.5 million individuals. I could do, but I won't, it's just ridiculous. But I'm going to put forward generic evidence based on our statistical data, survey evidence, a range of other evidence to demonstrate that 45% of customers would not have gone for the cheapest fare. And you win if you establish that, because you will not be ordered to pay damages over and above that, which properly reflect actual loss.
But my Lord, my learned friend, Mr Moser, hasn't done that. I've raised a realistic prospect, and the co-appellant, that there are multiple scenarios in which there wouldn't be liability. Right? I've done that. That's all I have to do in my respectful submission. And then my learned friend hasn't come back and said, oh, well, don't worry, because here is a plausible and credible methodology grounded in the facts for which there's evidence of the availability of data that will allow me later, when I actually do the methodology, when I actually get the data, to remove all of these problem issues.
So does it come down to a case management issue? If he then said, right, I now apply for disclosure from you in total, so that we can get a handle on each and every one of these categories, on your data, and then come back with a better methodology, that would be all right?
No, in some case that might work, but not this case. And the reason it goes back to that paragraph from Dennis. this case is not dependent upon the unilateral actions or the data of the defendant. If it were, that might be a response. But this case depends upon his class members. I don't know the first, I don't even know who they are. I am never going to be able to say to him, oh, don't worry, I've got all this bank of data about these class members that would enable me to tell you with anything approaching anything that this is what they would have done for that journey and that counterfactual on that day at that station.
It's in the tribunal's judgment. We have some data demonstrating the number of passengers who've paid full fare rather than a discounted fare. So you have, in a sense, some bulk data already demonstrating the scale of the problem. If the tribunal are right that it's de minimis, they may be wrong on that. But it's not as if there's a dearth of data.
Oh, absolutely. I absolutely do not accept that, my lord. The data here would have to go to identifying and therefore being able to remove all of those people who in the counterfactual wouldn't have bought the boundary fare. My 7 scenarios, as Mr. Jow will develop them. There is no data on that. No methodology for that. I will, in a minute, I'm going to finish. You know what? Because of time constraints, I'm going to.
Well, we've taken you off course a little bit.
But it's important. It is very important, my lords, that I try to deal with these. But it just means I'm trying to, on my feet, juggle what I do with the other. What the other
You were going
points.
to refer us to the American cases.
But can I just respond to that point though? It is when I raise a realistic prospect at the certification stage that there are going to be in this top-down methodology that faces me across the other side of the table, non-liability situations. It's for the claimant to establish his right to damages, and he mustn't be overcompensated. We know that from and he must only do a fair and reasonable job across the whole width of the class. And my point is, I'm pointing out to him realistic, not just fantastical make-believe nonsense points, but real points. And at that point, he has to say at the certification, no, don't worry. I can see your point. If I'm in a world that allows aggregated liability, so if I've lost my first submission, but if I'm in that world, then don't worry, because my expert has a credible, plausible, grounded in the facts, methodology for which there's an evidence of the availability of data that will allow me to take them out. And he can't, because they're all so individualized. There's no proxy, there's no sensible, coherent proxy, and in any event, he would have to put it forward. It would then have to be scrutinized by the tribunal. I would be allowed to critique it, if needs be, using my own expert, and at that point, the court would make a decision. I might even lose. But the point is that hasn't happened. And that's where I say the certification has gone wrong in this case, if I lose on my first major submission. And it will obviously become a lot clearer to you when you see the precise examples, and Mr. Jow will refer you to the relevant case law. But what I'm going to do, I've just come back to In re Nexium and In re Asicol. What I might do, my lords, and my lady, is just refer you to some passages in them and give you the broad submission, rather than sort of taking you to them and reading it out in the light of time. But I don't accept, my lord, that there's a meaningful distinction between what you just said about the psychiatric evidence for drug people. All I draw by way of analogy is the principle. The principle is that in a case where in the counterfactual, notwithstanding the liability position having been addressed, people still wouldn't have had a loss, because they still wouldn't do in that case, buy the generic drug, or in my case, buy the boundary fare. At that point, the US courts have said, for reasons of fairness, you have to be able to show that court at certification that there's a way of taking out those over liability situations. And that's the point. And what's said in the judgment against me on this point is, oh, well, it's very, very different in the US. And I accept that. I accept entirely that it's different in the US, but not on this point about basic principles of fairness. And my lord, what I would like to do, in light of the time, is can I just give you some references in re Nexium and in re Asicol, rather than actually read them. They're all both to be found in volume 4. One is at tab 30 and one is at tab 33. And they are both First District Court of Appeals decisions in the US. Nexium came first and had a dissenting judgment by Judge Kayata, and then a few years later, the same district court, in the same Court of Appeals in the same district, I beg your pardon, this time with a lead judge of Judge Kayata, gave a further exposition of the principles. But the basic principle is is very simple, and I'll just give you one reference to it, is that you have to be able to take out, you have to be able to show at certification that the uninjured class members or the transactions in which there were no liability can be taken out. Just trying to find a single one that is the best, just for the interest of time.
Well, there's a passage on at the very end of Asacol, page 161 of the bundle.
There is. I mean, that's probably as good as any. The plaintiffs have not shown
in the haystack point.
Well, I rely on that whole of the. But if one were to go to the passages on page 58 that's sidelined, the top of 59, the passages sidelined at 57, likewise at 55. I mean, obviously they've all been sidelined because I wanted to refer to them. So the same on 53. In other words, I would respectfully invite the court in its own time to just have regard to those sideline passages in both, and you'll see extremely clearly that what emerges is the proposition that I've advanced, that you don't pass certification if you can't come along and show at certification that you have got a credible way of taking this stuff out. And the reason is very fair. The reason is very obvious, I beg your pardon. It's obviously unfair to the defendants, because they might then be saddled with an over liability. Now, what I'll deal with in...
I'll just ask you to comment on the paragraph from Asacol cited by the CAT itself,
Yes.
paragraph 117.
Yes.
I'm just thinking what the CAT seemed to deal with Asacol, but not the other case. They dealt with Torres and Mercer Canyon.
Yes.
In Asacol 117, the judgment in Asacol at 55, and the last sentence. I'm just wondering what the US court was trying to get at. They seem to be suggesting that at certification there has to be, it has to permit for challenges to occur at trial in a manageable way.
Yes. Yes.
So you're setting up something which enables the issue to be properly determined at trial. In other words, that there may be people who fall outside, who've suffered no loss.
You have to set it up so that it's capable of being, the PCR has to come along at certification and show at trial there's going to be a method at which this can be dealt with in a manner that's fair to defendants. That's the point. And where it's an individualised question about what I would have bought in the counterfactual or not have bought in the counterfactual, what both of these courts of appeals are saying in the US is, well, that's actually quite difficult because it's so individualised. It's not impossible. There are various suggestions about presumptions, affidavits, unrebutted affidavits, etc., etc. But what they say, in particular in Asacol, is, well, that was your task. You should have come along at the certification stage and explained to me how in a manner that's fair to the defendant they were going to explore the counterfactual, because let's be clear, any case in which they wouldn't have bought the generic entrant in the counterfactual is a non-liability situation. They can't be made to pay for it. So what is your method? And they failed. They didn't come up with a method. And that's the same in this case. In my appeals, I respectfully contend my learned friend has failed. His expert has failed. They haven't addressed how to take these out, let alone in a credible, plausible manner based upon data.
And would you go one step further? If you've already identified, and I read that very carefully, that you say the CAT erred in dismissing categories as de minimis without proper evidence. If the CAT was correct and it was entitled to come to the conclusion that the no liability categories were de minimis, would you then accept I know you don't understand, you don't accept the premise, but
yes,
if that is correct, is the CAT then entitled to go on certify?
Well,
on the basis that there will have to be some exercise, but it may be very small.
Well, I'm going to answer it, if I may, in two ways, because I'm being very careful here, partly because I'm conscious that the case may go further. And the answer to that is, firstly, in every case, the PCR would have to come along with some evidence to show that. Right? Because you can't just assert, oh, well, we say it would have been de minimis. Our case is it wouldn't have been de minimis, but the burden is upon them.
The challenge has to be the tribunal almost saying of its own volition,
It did.
we think this is judicial common sense.
Yeah, we don't accept that. Mr.
I understand that. That has to be your challenge, that it's not judicial common sense. Because that might do away with the need for evidence.
Well, and maybe in some case, but not this case. Maybe in some case. But this is not that case, because we can all, whether we're members of the judiciary or otherwise, note the real world, that people can be in a hurry at a train station, or that people frankly don't care about 25 pence saving on a rail ticket, if that's the relevant boundary fare saving, or in any event they're going to be reimbursed, to give just some of the examples. There are many examples. I've got 7 scenarios that Mr Jow will deal with. It turns out that there are other tickets that are cheaper anyway. So in the counterfactual world, if these people are so focused upon only buying the cheapest ticket, and then they start to engage with the ticket staff, which is what is said to happen in the counterfactual world, then the ticket staff say, well, why don't you buy an advance fare then? That's a lot cheaper. Or why don't you buy a group save fare? That's a lot cheaper. So in other words, the critical point, my lord, is they're not buying the boundary fare, which is my learned friend's case. Anyway, Mr Jow will deal with them, but you can see the point. And the second answer is I wouldn't like to officially concede on the record today that even if it were de minimis and shown by evidence that is perfectly acceptable at certification. I don't have a stance on that, but I certainly don't concede it. And then that takes me on then, unless you've got any further questions, a change of tack. It's 8 minutes past 4 by my watch, and I would hope certainly by 4:30 if I could be given that indulgence to finish the 2 other. We had a slightly late start due to some missing bundles. I hope that's not being too cheeky. I'm very grateful. So now I'm changing tack. So that's what I have to say on the first 2 major topics. The third topic is altogether different conceptually. It is, I complain with great respect about the tribunal's analysis of Mr Holt's methodology on identifying what became known as the overlap. So just to be clear, the overlap is people who A, have a relevant valid travel card and have it on them, physically on them, A, and B, who whilst they have that travel card valid and on them, B, travel on a relevant in-scope journey out of London. That's the overlap that Mr Holt had to establish as a step in his methodology, and my ground of appeal is that the tribunal misanalysed that point. Now, Lord Justice Green, to take you your point, you said, well, is this really an error of law or is it one of discretion? In my respectful contention, it is clearly an error of law. It's exactly what happened in Merricks. Exactly. In Merricks, the methodology was said to be non-process compliant. So para 118 of the process was cited. Everyone agreed it applied. There was no suggestion that it had been miswritten in the tribunal judgment or miscited or anything like that. And the tribunal applied it in a certain manner. And then there was a point of law to the effect that they had misapplied it. And that went all the way to the Supreme Court. So in my respectful contention, misapplication or misinterpretation of the process test when it comes to its application to the facts of a given case is a point of law. So that's my answer to the point. And that's a complete answer to my learned friend's submission in his skeleton that there's no jurisdiction to even entertain this argument that I'm making, which incidentally was picked up and repeated by the tribunal in its PTA judgment. That's wrong in my respectful contention. This is a point of law. And what is the problem? The problem is that the tribunal found in no less than 4 places, if you want the paragraph numbers, they are 34, 148, 162 and 180, in 4 places that this overlap was, quote, challenging, unquote, or the most challenging. And in my respectful submission, that was a masterpiece of understatement. It is hopeless for my learned friend's expert, experienced and clever that he is, to think that he could come up with a credible and plausible method of determining the overlap. It is completely common ground that there is no data at all that actually establishes this overlap. Nobody can tell you for a historic transaction apart from this absolutely tiny category of, I think some people have some kind of electronic card, that they had a relevant travel card and were travelling on a relevant in-scope journey going out of London, because nobody holds that data. So there's no actual data, and Mr Holt concedes that he has to use what he calls a, quote, proxy, unquote, i.e. there's no data. And then a critical part of the proxy methodology was to do what was called a survey. And this is my complaint. Misapplication of the test. The survey that was intended apparently to establish this completely missing data wasn't ever produced. It certainly wasn't operated. There wasn't even a pilot or a draft. So it follows that at the time of certification, there was absolutely no actual data about the critical overlap, number one. Number two, there never would be any actual data. Number three, no data at all had been generated by the survey as part of the proxy, because the survey didn't exist. And what I respectfully contend is that that meagre proposal for a way forward doesn't satisfy process. That is not credible and plausible. It's not grounded in the facts, and it doesn't have evidence of the availability of data. And if it doesn't do those things, it fails process, and it shouldn't have been allowed. And yet it was the most challenging and critical part of the survey. And what's more, this is extremely important. One of the reasons this is advanced by my client is that this is an extremely important point for the future of this regime. Because if in practice I am wrong on this point and my appeal on this point doesn't succeed, then all that will happen in these CPO hearings going forward is that when an expert is faced with a difficult point such as this, indeed a truly challenging point such as this, or any other different difficulty pointed out in his or her methodology or evidence for the methodology, that person will just say, oh, don't worry, I'll do a survey. Don't worry. I haven't done it. I haven't designed it. I haven't written it out. I haven't done a pilot. I haven't even drafted any questions, not even a single one. But don't worry, I'll do it. And then you can get through certification. Or if you're allowed to do that, why can't you come along at the certification stage and when a defendant says, yes, but you can't deal with this, you just say, oh, well, don't worry, I'll do some other type of methodology on top of the methodology that's in the report that I've submitted. So for instance, don't worry, you don't really like my, or you think there are problems with my current method of aggregating damages, but I'll do a regression analysis as well. I haven't done it, but I will do it. You just use the word regression. Or you say, I've done a regression, you think there are problems with that, but don't worry, I'll do a simulation analysis. You haven't done it, but you say the word. Or you say, don't worry, you don't like my pass-on analysis using regression, but don't worry, I'll do a forensic accountancy analysis. And you just use those words. That's what's happened here. Mr. Holt has just used the word survey, as if that's a panacea.
Is that entirely fair? I mean, he proposed a survey to refine a weighted average model that he did put in front of the tribunal. So it was a refinement of his estimated model, not the actual model.
You're quite right on this point.
There wasn't a vacuum.
You're quite right on this point, but the reason that the survey had to come forward as a refinement was because the non-refined version of the methodology was hopelessly too unspecific, and it didn't actually deal with the overlap. That's the first answer. And the second,
the tribunal disagrees with you on that. They recognised it wasn't a perfect match for the overlap, but they didn't say it wasn't irrelevant evidence of overlap.
I don't accept that, my lord, for this reason. What they said was the methodology that I accept as passing certification is what you call the sort of, well, perhaps you didn't call it, but the groundwork for the proxy. That's my words. But then it had to be refined by the survey. That's what they accepted. But they didn't have the survey, and I've criticised it.
They didn't have the survey. I mean,
no, but they didn't have all the other parts that I've just mentioned either.
Well, they record certain. They have. We've got the data. We've got what the tribunal found, particularly in 148. So we've got the weighted average conclusion, and you say it's woefully inadequate. They record that Mr. Holt said that the estimates could potentially be refined through a survey, so it's accepted and acknowledged that he hadn't done that. So we've got what we've got, and the tribunal accepted that as adequate, possibly subject to further refinement.
But that's my point, my lord. That would happen in every case. So what would come along, and the PCR's expert would say, well, I can see that you're, to use a colloquialism, turning your nose up a little bit about how that methodology that I've actually advocated, actually put in my report, isn't really good enough, right? So it needs to be refined to be made more credible and more plausible grounded in the facts of this case. I haven't done it, but now I'm just going to use a word. I'm either going to say, oh, don't worry, I'll do a survey, or I'll do a regression, or I'll do a simulation, or I'll do a forensic accountancy. And that was what got accepted in this case, and that's where I draw the line. If you're going to say that the methodology you accept is the basics refined, you have to have a credible and plausible method for showing the refinement, and that was never done. And that's, I accept your counterpoint, my lord, and what you say about it, but that's my criticism, and what I say is an error of law in applying or understanding the application of the process test. And I do rely upon, I won't turn it, I'll give you the citation, but in the case of David v. Loblaw in the Ontario court that we cite in the skeleton, it's a bundle Authorities 5 at tab 39, paragraphs 98 and 99. They say, in terms, you can't just rely upon an expert who takes a trust me approach. Trust me, I'm an expert, I'll be able to do it. You have to go further than that. And I would say that you would abdicate, with great respect, your gatekeeping role that is incumbent upon the tribunal per Merricks in the Supreme Court if you just say, oh, don't worry, he's an expert, he'll be able to do it, without telling you at least the rudiments of how. I mean, and I'm not interested, I accept that in some case, potentially a survey might even be helpful, might even be really helpful in some case, but I'm not worried about some case, I'm worried about how a survey performed presumably at the very earliest at the end of 2022, if I fail on this appeal and it doesn't go any further this case, is going to establish the overlap in October 2015 for a journey from Waterloo to Woking via Clapham. How is a survey going to help with that? I just don't know, and it's never been explained. It's not credible and it's not plausible, not grounded on the facts of this case. And that's why I draw the line. And the same applies, I'm going to skip over this so I can deal with my last point. But the same applies for the reference in para 161 of the judgment to the use of a survey for taking out point-to-point fares. I think Mr. Giles is also going to deal with this. It just says survey, and that's it. And that doesn't meet the hurdle. There are two additional problems before I move on to my last submission with the survey on the facts of this case. As I say, in some other case, there may not be this problem. There are two absolutely sea changes in travelling behaviour during the currency of this case. It's absolute sea changes. The first one is the transfer from buying travel cards in hard copy and putting them in the wallet to instead using Oyster or debit card pay as you go. So fundamentally changed travelling patterns during the currency of this case. The second one is obviously COVID. And we pointed out both of these sea changes, and we said, how is a survey that's never been constructed, let alone performed, so it'll have to be done in the future, how is it going to tell you anything about what travelling patterns were, including for a period pre these two sea changes, or even in the middle of one of them, let alone pre the other one? Silence. No answer. That is not credible and not plausible.
Do you accept that disclosure might assist Mr. Holt, or not at all?
No, I don't accept that it'll assist at all, because it goes back to what he needs to know is the travelling behaviour of his individual putative opt-out class members. So that's an individualised inquiry. What would they have done by way of their travelling habits and their travelling transactions in the counterfactual? I don't know anything about that. As a defendant,
nothing in the possession of the defendants would assist the process.
Nothing in the possession of the defendants would assist in getting to the individualised nature of the question. Exactly. And because it's too bespoke and individualised.
The data which is collected for the purpose of the travel card agreement and the apportionment methodology presumably involves each operator collecting disaggregated data on use of card as against journeys. Is that not relevant?
No, that doesn't go to this issue. That travel card agreement, I'm not an expert and I'm happy to take instructions if there's a particular point, but that travel card agreement goes to how do you, in a sort of conceptual manner, allocate out between train companies the revenue that's received by either them or Transport for London from sales of travel cards, but it doesn't go to the, doesn't even go to the overlap as between use of a travel card and taking a relevant out of London in scope journey. It doesn't bear on that question. It's addressing itself to a different issue, and I think I'll be corrected if I'm wrong. Can I just take 1 second? Just I put it like this. My learning, I have checked it. Oh, I beg your pardon.
No.
Sorry. My learned friend doesn't rely upon the travel card agreement for any overlap purpose. So that kind of proves the point. So, my lords, my lady, that...
Not right, but I'll explain.
Okay. Well, I will listen very carefully, and we have people who know about the facts who I can listen to, take instructions, and deal with it in reply.
We'll deal with it in reply
As necessary. So that leaves me, by my watch, 7 or 8 minutes for the fourth topic. So this is my appeal against the strikeout. My strikeout didn't succeed, and I appeal against it in both respects. There are two respects. One is what we call third-party retailers. So they are people like Trainline.com, though obviously not limited to Trainline.com. And the second point concerns advanced fares. They're completely different points. I'll take them one by one, 4 minutes each. So what we complain about is that there was no sensible pleaded or evidential basis for saying that our allegedly abusive behaviour in failing to make boundary fares sufficiently available has caused our competitors also not to make boundary fares sufficiently available. This wasn't a pleaded claim. It's now said to be analogous to umbrella claims. But in all my years at the bar, I've never seen an umbrella claim that comes anything close to this. Umbrella claims are for pricing. What is said is the cartellist has caused prices in the market to be too high, and that past behaviour in causing prices to be too high has caused some other non-cartellist in the same market to raise their prices above the competitive level. There has to be a causation, and it's a backwards-looking causation by reference to something that a non-cartellist has done, having been caused by way of price by a cartellist or an infringer. That isn't a pleaded claim in this case, and it's not coherent. There is no sensible way in which you can see that this case, which is about non-pricing behaviour, this has got nothing to do with pricing. That the non-pricing behaviour of somebody who is not our agent, say Trainline.com, has been caused in the past to be a certain way because of the behaviour that my client has adopted. It's not pleaded, and much more importantly, because it's not a pure pleading point, is that it's impossible to see how it's coherent. This is a case in which the Trainline.coms of this world and my client compete in the sales of the same things. We're both selling train tickets for the same journeys.
It's said by the tribunal, and I think by Mr Moser, as your agents.
Yes, I'm going to come back to that because there's no foundation for that, which is why we took a strikeout point.
If they're not agents, do you sell blocks of tickets to them to sell as principals?
This is all dealt with. If I'm going to give you the references here to the amended response, which is supplementary bundle volume 1, tab 3 at 83. Because it's very important. There was no factual foundation for the assertion that's now repeated, indeed as his premier point by Mr Moser, that in these respects the third-party retailers are our agents. On the contrary, the evidence, which is why I made a strikeout on the back of my evidence, was that they're not agents.
Well, that's why I asked if they're not agents, they only have the right to sell the tickets if you have, as it were, sold them blocks, so they then sell as principals. Well, how otherwise do they get access to the ticket?
In the time available, I don't want to unduly curtail this. This is dealt with those responses in the response by reference to a detailed section of some pages of Mr Backway's evidence. It explains that there is a rail delivery group and there's a complicated set of arrangements whereby the TOCs make use of people that they call third-party retailers for the sales of tickets, and it's not an agency relationship. So I have to leave it at there for now. But that's the uncontroverted evidence. That's why what he now says is his principal point of reply is a bad point. They're not agents, and there was no evidence to say that they are. There was lots of contrary evidence to say that they weren't for these purposes. But more importantly, because it's not just a pleading point, is if I am competing with, I'm obviously competing with them for the sales of that ticket. They are my competitors. That was accepted by the tribunal. And yet it is said, and how do I compete? How does my client compete with Trainline.com for the sale of a Woking to wherever ticket? Answer, in the method of sale. That is the only means of competing. So I wish I knew a name of another one, but I'm just going to keep saying Trainline.com. They compete because they think, presumably, that their website is wonderful and flash and fast and they're efficient, and they compete because they think, no doubt, that they deal with refunds and customer complaints better than we do, and what have you, and that they've got great advertising and what have you. no problem. But that's the point. They're actually competing with me as to how they sell the ticket. And yet the allegation here, not pleaded, no evidence, is that how I have behaved in the past has caused them to behave in the same way as me. And that's the bit that's incoherent and why this allegation should be struck out.
It's not normal competition. This is an entire intra-brand competition. This is not competition between brands. Even if it's sold by trainline.com, you're still selling the same operator's ticket.
I totally agree, my lord. That's my point. The only basis upon which they compete with me is how they go about selling the very same thing. And yet the allegation that is now said to be arguable and should go to trial is that I have behaved in a certain manner by way of selling my ticket, and that has caused them to act in the same way in selling the ticket. I just don't understand it. I compete with them.
The facts.
Sorry?
It might or might not be. I mean, let's put it in the bluntest and crudest terms. If you can get away with it, it encourages people who are your distributors, your agents, whatever, also to get away with it because you are able to do it. If you couldn't, why would they be able to get away with it?
No, but my lord, an umbrella...
I'm not saying that's right. I'm just saying
Yes.
that's almost the same analogy, isn't it?
If if what they're doing is trying to undercut you.
Well, it's difficult, my lord, on that because there's only a very limited amount of, well, almost negligible price competition for the same good. But what they do distinguish themselves between is the method of sale. And therein lies the rub. My learned friend's case, if it's to be arguable and go to trial, assuming it were ever pleaded, which it's not, he'd have to say that the way that I have behaved in selling my tickets in the past has caused them to behave in the same way. Has caused them to behave in the same way, and that's why I can claim damages in respect of their sales. But my point is, how I sell my tickets is the very means by which they seek to differentiate themselves from me. So it's an incoherent claim.
I'm going to stand back from this. And again, assume for the sake of testing the argument you're dominant, because this doesn't arise if you're not. You have control over the system. Do you have, as part of your special responsibility, the obligation to set up a system for the distribution of tickets which doesn't involve double charging, whatever you want to call it, overpayment because of travel cards? Is that part of your special responsibility?
No, not in this regulated environment where the situation is that the third-party retailers are entitled to come along and they're entitled to sell the tickets pursuant to this complicated set of agreements. But they specifically have the ability, indeed their whole competitive raison d'etre is to compete by how they sell those tickets. Otherwise, I mean, if they had no means of differentiating themselves from me, they presumably wouldn't sell any tickets at all.
You have an obligation under the travel card agreement to, quote, to honour the travel card. How can you honour the travel card if you permit somebody who's selling your tickets to flout the travel card? Again, I'm putting it in extreme terms, purely and simply to identify an issue, not because it's necessarily right or wrong.
Well, my lord, I think the only way I can deal with this, given that I have to spend at least 2 minutes on the final point, is to refer you back to the evidence that's summarised. It's about a page of the pleading, which goes back to Mr Backway's evidence. So it's supplementary, volume 1, tab 3, para 83.
We'll definitely have a look.
And I'm very grateful. So in
83.
yes, it may be page, I beg your pardon, yes, page 83. Thank you, my lord. So then it takes me on, I'm so sorry that I've overstayed my welcome, but I can do this last one. I'm very grateful. Advance fare. So this is discrete, completely separate point, one that I sought to strike out and I failed, and I say that it's that was an error of law. But it's, I'm pleased to say, a short point. So it goes like this. There can be no coherent allegation that it can be abusive for my client not to make available double discounts or combined discounts on our fares. That's not a coherent allegation of abuse, that I failed to make 2 discounts available for the same journey. Yet an advance fare is a discounted fare. Everybody knows that. And what's more, it's done for perfectly good reasons, to try to encourage people on certain journeys, whatever. A travel card is also a discounted fare. That's why you buy them. You buy them, whatever, for a week, and you get 50 journeys, but in practice you've only ended up paying for 3, because that's the point, it's a big discount. So to have an advance boundary fare, by definition, means combining 2 discounts, the advance discount with the travel card discount. But on what basis, I ask rhetorically, can it conceivably be said that LSER, even if dominant, which of course I don't accept, but even if I were, should allow multiple discounts for the same fare? I can't even understand the allegation that that would be abusive for me not to make available double discounts. As Mr Backway explains in his evidence, my client is free to set it whatever fares it likes within the constraints of the regulatory regime, and it's not suggested in the pleading or in the argument that somehow this is a breach of the regulatory regime. All that's said now, and by way of reply, because I objected to this point right throughout this case, was, oh well, don't worry, there quote should unquote be such advanced boundary fares. That's all that's said. Well, you should make them available. It's abusive for you not to make them available. But why? I simply don't understand it. Why should I make available double discounts? And nothing is pleaded, there's no argument, there's no evidence, there's no anything about it. It's all just completely brushed under the carpet. And what's happened is that, with great respect to the tribunal, and this is my very final point, they've misunderstood the argument. What they said was that we don't accept that a boundary fare is a discounted fare. But that's not my argument. I never made that point. I said, as I've said to you, the two discounts are the advance discount and the travel card discount. Those are the two that you're bounding together. I didn't say that the boundary fare, and there's an error in the judgment on this.
What they were saying was simply this, that you're a cyclist, I'm not. We both go on a journey, it costs 20 quid. I've got a travel card, so by definition I've already paid for part of the journey. But we've both charged 20 quid, you and me. So that's in effect reverse discrimination. We're treating different people alike. Because I'm not getting the credit for that which I've already paid for.
Well, my lord, that's not pleaded, it's never been put, it's never been argued, there's no suggestion of that. So
I just wondered if that was slightly clumsy what the tribunal was saying.
I think the way it's put against me is simply that in the same way that if it were a non-advanced fare, in my learned friend's theory, you've already paid for the first bit, if you then go on beyond the boundary and do a second bit, well, it must apply to an advanced fare, but it just doesn't deal with the point. The point is that the advanced fare for the first bit on this example is already discounted. So what you would definitely be doing is saying that if you bought a boundary fare for that particular example, you would be combining these two discounts. You can't escape it. And that is ignored, and it's not coherent to say. And then my learned friend relies, my learned friend, to be fair to him, doesn't really try to defend that. And the judgment below says, actually we can see the force of Mr Harris's points on that issue. But he says, I don't win on the strikeout because you should all go to trial anyway. And I say, why? This is a discrete point. It's just taken me 2.5 minutes to explain it, and it should be grasped. If it's wrong, it's wrong. It'll always be wrong. And we shouldn't add to a very gargantuan and difficult trial with issues that should be struck out because they're hopeless. So unless I can assist further, may I just take one second? I'm most grateful to be reminded. One point that I forgot to make on my first submission about aggregated liability, and I apologise, is that the Broad Acts, there's no authority for the proposition that the Broad Acts applies to liability as opposed to quantum. So unless I can assist further, those are the submissions on LSER's appeal. I'm most grateful.
Thank you very much, Mr Harris. Right, we'll adjourn then, 10:30 tomorrow morning.
Rise.